The hearing is in the matter of CFI 016-2021 and CFI 023-2021 before Justice Roger Giles and is being held by way of video conference. Any orders or directions made after or during the course of this hearing will be issued by the registry in Dubai on the judge's instructions. The claimant is represented by Charles Russell Speeches, LLP. Lead counsel is Stephen Doherty. The defendants are represented by Onoma, FZE. Lead counsel is Faisal Osman.
Yes, well, gentlemen, I should have checked. Can you both hear me and see me all right? I think when you couldn't hear, Matha made the usual announcement about being a hearing in Dubai, etc., which you're familiar with, so we won't bother about repeating that.
Thank you.
All right, well, gentlemen, I think we can get one thing out of the way. Thank you for your submissions in response to my query about whether the other tenants should be parties to the action. Both sides say, on the defendant's side, at least in relation to this application for immediate judgment, that the other tenants need not be joined. That being so, and when the parties had prepared for the hearing today, before I raised my query, I proposed to take a practical course, having regard to the overriding objective, and that means that I expressly do not rule one way or the other on whether the other tenants should be parties, from which you may see that it's not something as to which I'm convinced that you are both right. That means whether parties now or at any other time, I'm not saying anything about that. I'll hear and decide this application as the action is presently constituted, and if and when necessary, the question of the necessity for the other tenants can come up at a later time. All right, so we can proceed with the application. I have read the various witness statements, and I, of course, have read your extremely useful and comprehensive submissions. There's one thing I should say. Both Ms. Sheffield and Mr. Fedrigoli's witness statements are, to a considerable extent, not witness statements. Witness statements are statements of evidence, and it should be made understood that I am not going to pay regard to the submissions that both contain their thoughts about why the other side is right or wrong. I am going to decide this application on the submissions that you two as counsel make to me based on facts which are found sometimes quite occasionally in those witness statements. All right? Okay. Mr. Osman, then I think you're the applicant, so you should commence, and you now have a much better understanding of how Mr. Doherty puts his case, so that is on the question of authority. So I think it still remains that you should be the person starting off. So away you go.
Yes, thank you. Just because it's a video hearing, I really should introduce the attendees on the call very briefly. Of course, myself and Mr. Doherty. With me is Mr. Fedrigoli, and I see with Mr. Doherty is Mr. Smith, Miss Sheffield, Mr. Cato, and Miss Fakini as well. You will have received electronically, I hope, a number of bundles. Effectively, they are the hearing bundle, which has been split into 3 parts. There's a law bundle split into 2 parts, a core bundle, and also from my learned friend, a law bundle, and there's been some supplementary bits and pieces, mainly to do with the preliminary question which Your Honour asked, which we can put to one side, but I would direct you mainly to the hearing bundle and the core bundle as well, with some reference to the authorities. Your Honour, can I just put a summary of where we are with this application. I hear what Your Honour says in relation to the content of Mr. Fedrigoli's witness statement, but that being said, a very substantial aspect of our case has been set out in writing already, and certainly, may I suggest, in skeleton arguments. So I won't trespass upon your time in repeating at length much of what is said in certainly in my skeleton argument. But what I'll try to do is distill down really where we are in terms of the dispute to be determined. There will also be a few documents which I need to refer to just for highlighting various points, but ultimately I suggest it comes down to this: is the claimant IGPL's thesis on authority right? Secondly, are the defendants, ourselves, the applicants, correct when we say the tenancy agreement is what has been termed by the authorities as a rainy day sham? And thirdly, in respect of either, should the matter proceed to trial? The structure of what I'm going to do, some background. Again, I won't go through the details of the background in extensive detail, because I suggest that has been traversed quite well in the witness statements. Primarily, Mr. Pretlove's witness statement, and I can just give you the references. It's paragraphs 4 to 14 of Mr. Pretlove's witness statements, which is at page 28 of the hearing bundle. And what he does is, I suggest, go through the history of the proceedings, certainly in the BVI, but more generally, I suggest in some detail. Again, I won't trouble you by going through that in detail. I'm sure that Your Honour has read it with care. In terms of the issues, first, authority, the claimant IGPL now puts its case on authority on two alternate theses, and they give rise to the following questions. First, did Abdullah have lawful authority to create the tenancy agreement by donated shareholders' rights, which would overreach the boards? That, we say, is a new, or at least newly articulated, basis upon putting the authority thesis, or it is an authority thesis which has been newly articulated. Secondly, if the answer to that question is in the negative, was Abdullah the company's agent via a power of authority donated by the company's directors? So shareholders out, number one, directors out, number two, if I can put it as crudely as that. We say, on behalf of the defendants, that IGPL have the law muddled on both those propositions. We say that the answer to both questions, both theses, is should be in the negative, and we say, as a consequence of that, that is the end of IGPL's claim for want of authority. So that, in summary, is how we approach the authority aspect of the case. Sham, essentially, the parties' positions are as follows. IGPL say you should not look beyond the face of the tenancy agreement as a document. We say this is a classic rainy day document. It wasn't commercial, and it didn't contain terms which were commercial, or indeed in some respects could not be executed. IGPL has invited me to give some assistance, and I see this from Mr. Doherty's skeleton argument about how the sham operated. I suggest that a lot of that ground has been traversed in the witness evidence, having in mind what Your Honour has said, of course, but certainly in my skeleton argument. But I will take up that invitation that Mr. Doherty puts to me with reference to several documents. And I will return that invitation by suggesting that there are two key answers for IGPL to answer, two key questions that IGPL should answer. The first is, why was it kept a secret? And the second is, why were its terms never executed for 6 years, i.e. the time that it was created in 2013, up until 2019, when it was first revealed by Lennox Pattern in the BVI to the receivers at that time, legal counsel, in respect of the appeal, which had then been abandoned by the Al-Sari. So that gap from 2013, when it was allegedly created, to 2019, when it surfaced, why was nothing done in terms of the execution of its terms or anything else to indicate that it was, to put it in simple terms, activated? The second aspect is what we say, the characterization of a rainy day agreement. I keep referring to rainy day agreement. Your Honour will have detected, no doubt, that that phrase comes specifically from Midland Bank and Wyatt, and I will return to that authority in one moment. So that is the outline of sham, and those are the two questions which I respectfully suggest are key for IGPL to turn their mind to, and that, I hope, gives the assistance that Mr. Doherty was asking for when he made the invitation, his skeleton argument. On immediate judgment, we say that the action is fundamentally deficient and it's not likely to improve for IGPL. Of course, IGPL's response to that is that there should be a trial sometime in the future, because it should have the opportunity to develop its position with and in evidence. The key point is the tenancy agreement's terms. How and why those terms appear as they do and were created are inquiries which are answerable and resolvable by the creator of the tenancy agreement. And there is only one single creator of the tenancy agreement, and that is Abdullah Al-Sari. He is IGPL's agent, was at the time. He is IGPL's manager. He knows the issues. He has done 4 years. He has steadfastly stayed in the shadows throughout the whole process. So where IGPL suggests that there are many unresolved queries, the straightforward answer to that is that the person who is able to answer those queries is Abdullah himself, and he has elected not to come forward at all. As a general observation, the Al-Saris, we say, and its proxy IGPL are well resourced and commercially experienced. Abdullah is the patriarch of the family, and he has ultimate control over everything, including IGPL. And can I turn to the first document I will refer to in the course of my submissions, more than anything else, to check that the process works? It's hearing bundle. And can I ask, just before I continue, has Your Honour, I know Your Honour practices ordinarily to print the material out. Have you done that on this occasion, or are you referring to the material electronically?
Not when there's 1,000 pages of annexures. I have the court documents on an iPad. I can go to them. Occasionally it's a bit slow, that is all. Yes.
Frankly, I would have been surprised if you did print out over 2,000 pages, but I thought I would ask. Hearing bundle 1305. 1305.
I need an initial download to get into that bundle at the moment. What? Keep talking and tell me.
I will do. This document is a translation of IGPL's trading license. How it came about is that very early on in the proceedings, there was a request for inspection made by the defendants, and one of the items requested was IGPL's trading license. That trading license, the Arabic version of that trading license was provided. There is a translation of it. It has the dates of the license. That is not the important aspect which I wanted to draw your Honour's attention to. The aspect I wanted to draw your Honour's attention to is the stated manager of IGPL, and that's Abdullah Al-Sari. So it was to prop up the point that I was making, that Abdullah is the patriarch of the family, and that he is in control of IGPL, which is to prop up the point I was making about the source of the various matters of inquiry that my learned friend raises in his skeleton arguments, which he says ought to be resolved. So that was the document. If your Honour has it, then that's good.
I do have the document, but that is your point.
That is my point.
Yeah.
And applied, we say that the defendants should not be refused relief because Abdullah has deliberately, we say, left everyone guessing about his motivations. And we also ask Your Honour not to lose sight of what is an intolerable reality, and that is standing back from this all. Abdullah made the tenancy agreement with himself to make sure that his family would never have to leave the flats, the London properties, or indeed pay a penny more in order to stay there. And also, the reality of the matter is, if the flats were owned by Mohammed and Majid, entitled conventionally, they would have been attached to the judgment order, and they would have been enforced against long ago. We say, as a matter of introduction, this is a classic case of using intermediaries to frustrate judgment creditors, and that allegation has always been put squarely by us, and indeed in the BVI as well. And we also say that the court can draw an adverse inference from Abdullah's failure to respond to obvious questions that call for obvious inquiry. And
if this introduction has become more than an introduction,
yeah,
would it be better to get back to authority, deal with authority, and then deal with shame?
And it was going to finish. My only point was that we will refer to GFH, and in fact, Your Honour's remarks in GFH agency. It has been quite difficult to precisely pin down what the case on agency is, and the way in which the matter was put into play. Again, can I refer to the hearing bundle at page 28, which is Mr. Pretlove's witness statement.
Mm-hmm.
Paragraph 10.
Paragraph
10.
Yep.
And it's the dates which I wanted to draw Your Honour's attention to. The process in the BVI was that the Majid's final appeal for the charging order effectively came to an end in April 2019, and it then transpired on the 27th of June, and this is the letter by Lennox Patton in response to what took place at the appeal. That is when, on the 27th of June, the matter of the tenancy agreement first came to light. So that's the beginning of the process. In terms of how the question of authority started to unfold, at page 1154 of the hearing bundle,
Yes.
this document are particulars of claim that were lodged in support of a Part 8 claim that was made by Igpl preceding this claim. One line of history, the Part 8 claim never went anywhere because there were issues to do with service, and it was eventually struck out for procedural related issues. But at paragraph 5 of the case as put by Igpl in that Part 8, which was an application for declaratory relief, is that the applicant was granted a power of attorney for Lodge Hill and West Dean in investment. That appears to us to be a incident or allegation of express actual authority granted by Lodge Hill and West Dean Investments to Abdullah al-Sari in order to create the tenancy agreement. That was the position then in 2020 at the time of the Part 8 claim. That does not appear to have been maintained, and that has changed. And the position now can be found, if I can take your honour to the core bundle. At page 32.
Is that the particulars of claim?
Yes.
Paragraph?
At that stage, there isn't really anything on authority at all. And the best that we can find in relation to what's said is at paragraph 9 in respect to the tenancy agreements. And it just simply says that the tenancy agreements were entered into. So there isn't a explanation of what authority is. There isn't any mention of it at all.
Wouldn't it be better to look at how Mr. Doherty says there is authority and respond to that?
And I was about to do that. And I can
short. Let us not go round and round in circles. Let's try and focus, please.
Yeah. Then I wrap up the point in this way. We asked in the defence, and it's been articulated in the reply and in evidence as well. So the substantive argument about authority is, again, in two phases. And so can I deal with each one in each phase? The first new way in which authority is put is that the claimant suggests that Abdullah had consent to bind the companies into the tenancy agreement via the POA, the 2008 POA, and what I've called the UAE POA. The second basis, again, donated by directors. Can I deal with the first basis first? And really what that is a suggestion that shareholders' authority to create commercial relations regarding the company's property can be relied upon. That concept, i.e. the UAE POA, it's a wrong-headed theory for a few reasons. And the first thing I ask you to do is to look at the POA itself, and that's page 913 of the hearing.
I have that.
I'm sure you want to look to it. It's not entirely clear. It's a very, very general POA. It's not entirely clear, and I would invite Mr. Doherty to assistance on this. What precise provision of the POA appears to be relied upon insofar as the power which is being asserted over the shares of the BVI companies. Again, it is a very general POA, and the suggestion might be that because of its generality, that suffices. But there is certainly no reference to the particular shares of this particular BVI entity, which is an overseas entity for the purposes of a UAE POA. So that is the single instrument that's being relied upon. But my point is, it is impossibly general in terms of a POA. I won't dwell on that for too long, though. The point in relation to what the POA does, though, is as follows. It suggests that Abdullah has the power, he can exercise Majid and Mohammed's power in respect of those shares. What is not entirely clear is what power he was exercising. Can I take Your Honour to the Articles of Association for Hortin? And would you take it from me that the articles for all of the companies are fairly similar? They're fairly standard articles, and I'm sure there are ones that you will recognise because they tend to be in the model form. 871. Here, 871.
That's in a different hearing bundle, a different part of the hearing bundle, isn't it?
2.
Yeah. Again, I've got a slow download. Tell me what the point is, please.
This part of the articles for Hortin deals with the procedure at members' meetings, and it's a fairly well recognised and well trodden procedure in terms of how resolutions are passed, etc., and what has to be done. The point is this: none of the procedural requirements were in fact complied with in terms of what the claimants say was a decision made by Abdullah. The answer to that is it doesn't matter, because Geomatic effectively resolves those shortcomings, and there's heavy reliance by my learned friend on the Geomatic principle. So applied, what is being suggested is that the POA, which is general, gave Abdullah a power to apply the rights of Mohammed and Majid's as shareholders, their rights that attach to the shares for the BVI companies. And that, of course, included the rights to make a shareholder's decision. The process in how that decision is made is contained in the articles, what I've just taken you to. Those were not complied with, My learned friend says that doesn't matter because geomatic cures those defects. We say in relation to geomatic, the difficulty that my learned friend has with that is that geomatic requires that the consent and knowledge of all shareholders, unanimous or otherwise, must be, particularly the knowledge, must be in place before the geomatic principle is engaged. The trouble with that is that it was demonstrably not known by Mohammed and Majid that this is what Abdullah was doing. I say demonstrably because Your Honour may have seen references to affidavit evidence that was served in compliance with the terms of 2 freezing orders, one made primarily by the English courts because the properties were in the United Kingdom, the second made consequentially by the courts of the British Virgin Islands, which have effectively froze the shares of the companies. And if Your Honour has it downloaded and available, can I take you to page 310 of the first part of the hearing bundle?
Can I just see where we're going?
Yeah.
Really, your answer to the reliance on geomatic plus power of attorney,
yeah,
is that where it falls apart is that geomatic requires that the shareholders, here Majid and Mohammed,
yeah,
applied their mind, as it were, to the decision to grant authority.
yes.
You say that plainly they did not. That's where you say the flaw is it?
That's flaw 1, and
Right.
what I was taking to. I don't need necessarily, Your Honour, to read it. I can just give you the reference. Yeah. It might be easier. Otherwise,
that's right. I have that now. What was the page again?
It was, but hearing bundle part 1.
Yep.
310.
Nearly there. I was nearly there, but it has now crashed on me.
Shall I read it? Is it easier just to read it?
Just tell me. Yeah, page 310. Anyway, I'll look at it later.
I'm sure. But I just wanted to give you the reference. If I'm giving you references, can I give you 310 and 314? Yep. 310 is Mohammed's affidavit it's the ordinary affidavit in reply to disclosure requirements for a freezing order. 310 is Mohammed's, 314 is Majid's. They are pretty much identical. I haven't been able to see a difference between the two of them. There might be a word here or there, but they're pretty much identical. The point is this: at paragraph 9 of those affidavits, it says as follows in relation to the flats. The most I can say at this stage is that I'm not aware of any declarations of trust or express nominee relationships relating to the flats. The flats are used by my family, including nephews and nieces, when they're visiting London. I'm not aware of the existence of any claim to any beneficial interest in the flats from any family or non-party. I have not, however, received sufficient information or do not know who the ultimate beneficial owners of the company properties are. That's the highlight. Earlier on in the affidavit, where he deals with Hortin, Lodge Hill, and West Ely in particular, there is no mention of the tenancy agreement. There is no mention of any encumbrance. There is no mention of Igpl. And the takeaway from those affidavits is that it appears plainly that Mohammed and Majid, because both affidavits are very similar, knew nothing about the tenancy agreement, certainly didn't mention it as an encumbrance on the properties, certainly didn't mention it to in terms of what the value, market value of the properties would be for the purposes of disclosure. And it appears, for all intents and purposes, that they were ignorant of what had been put in place by Abdullah. Critical date, 30th November 2014. 30th November 2014. So you want to all remember that the TA was created in 2013, and perhaps slightly forgiven now for the convoluted route as to how date-wise as to how we got here. But this is really is what matters. In 2014, Mohammed and Majid did not know about the TA after it was being created. So that, we say, attaches to the point in relation to geomatic knowledge, full knowledge, etc., an absolute requirement of geomatic before it can be applied in order for the curing of the defects in relation to the creation of a resolution that has to be done by the company's constitutions. And I took you to those aspects of the company's constitutions earlier. In short, geomatic doesn't work.
Right.
So that's the first.
Sorry, you said that was flaw 1.
Yep.
On the geomatic plus power of attorney argument.
And
there
then
are flaws that you're putting to me.
That's flaw 1, geomatic.
Right.
Then Saban, if we can move to Saban, which is the other authority which my learned friend relies upon in order to demonstrate that what was done by Abdullah in relation to the power of attorney is sufficient to create the tenancy agreement. Saban is actually fatal to IGPL's case for the following reasons. And this, the first reason is really the fundamental flaw that IGPL have fallen into in how they use the POA to say that it can be a source of authority for the creation of the tenancy agreements. What IGPL have effectively done with this approach is they have deleted the boards. And what I mean by that is that they say that the source of authority to create a tenancy agreement comes from and came from the shareholders by way of a resolution created by Abdullah. I've dealt with the flaw in whether that resolution was properly made because of geomatic. But Saban appears to be relied upon by my learned friend to suggest that it's a cure for the fact, or rather, if unanimous consent is given, that's enough. So unanimous consent can get given. Because unanimous consent is given by the shareholders, then that is enough to create contractual relations on behalf of the company. And of course, that we say is incorrect. And Saban is fatal for these two reasons. First of all, it confirms that the execution decision of a resolution decision made by its members, the execution is done by the directors. In that case, Saban, that was a tortious claim for breach of duty brought against the directors of the company. It was called Spectacular. It turned into Saban. And what was said was that the directors didn't execute their duties properly, etc., when granting a POA to allow for the sale of various parcels of land to an individual who frankly shouldn't have sold them. The point is this: Saban confirmed what the position is, and that is it's not just enough to have a resolution, because the resolution is a decision by the members of the company as to how what the company should do, but it has to be an execution done by the board, the directors. In this case, the company was, the shareholders are not also the directors. They were different. I mean, as your Honour knows, in some cases, the shareholders and the directors are the same person. So a decision can be made by resolution and it's executed by the same pair of hands, albeit wearing a different hat. But that's not what happened here. There is a different board. And Saban makes that proposition clear just by the nature of what it is as an action. And so that recognition in Saban that it is the directors that must do the business of the company is fatal, we say, to the claimant's case. That's point one of why Saban is fatal. But there is another point as to why Saban is fatal. And I will need to take you to the authority. And if you have it, then that is good. If not, then I will read from the paragraph that matters.
Yep. Tell me the reference to it. I need to go back to the authorities bundle, I take it.
This is where I'm going to slightly struggle, because this is not in my authorities bundle. It's in my Learned Friends, which was separate, and that link for me hasn't worked. So I've had to download the authorities separately. But it may be easier to give you the paragraph number of Saban and then read it. So
yes, that would be best,
because otherwise it just takes too long.
Yep.
Paragraph 3, nice and early, of Saban, and it reads as popular. Saban and Spectacular are the same company, just as a matter of background. It reads as follows: Spectacular also alleged the issuing of the 5th POA, which is the POA in question, was a breach of Section 80 of the International Business Companies Act 1984. This is the point. Section 80 of the International Business Companies Act 1984, which is reproduced, that relevant provision in Saban, reads as follows: any sale, transfer, or other disposition of more than 50% of the assets of the company incorporated under this act, I pause, that captures the BVI companies, continue, if not made in the usual or regular course of business carried out by the company, shall be made as follows: A, the proposed sale, transfer, lease, exchange, or other disposition must be approved by the directors. B, upon approval of the proposed sale, transfer, lease, exchange, or other disposition, the directors must submit the proposal to the members for it to be authorised by a resolution of the members. Pausing. What does this mean? It means that in the BVI, as per Section 80 of the International Business Companies Act 1984, there is a requirement before there is a disposition which attaches to more than 50% of the assets of the companies. Now, obviously, the London properties are the assets of the BVI companies, so this bites. Upon biting, the requirement is that the disposition must be approved by the directors, and then it flows down to the shareholders stroke members, i.e. directors make the proposed sale, and then it flows down to the shareholders to confirm. There's an obvious reason for that. It's that because the disposition of land or sale, etc., is so important, there must be a check to make sure that everyone, effectively all parts of the company, from the corporate directors to the shareholders, know what's going on. So that's the flow of information between the two levels. Point. In this case, on the first thesis, where Abdullah is said to have created the TA based on his authority as a shareholder via the POA, that doesn't work, because it is a requirement that the approval must be done by the directors, and it wasn't.
Based on Majid and Mohammed's positions as shareholders?
Yes.
Yeah, you said Abdullah, okay.
Sorry, my mistake. Sorry, yeah. My mistake.
Well, does that effectively mean that the duomatic principle does not apply where you are disposing of more than 50% of the company's assets?
It means the decision to do so, to instruct the directors, may be a duomatic style decision, theoretically. So that can be the instruction that goes up to the directors. The next process is the missing process. The directors then have to propose the sale, etc. The directors have to do that. It then flows back down to the members, and the members have to effectively ratify that position. The point I'm making here is that duomatic only gets IGPL so far, if of course the points about duomatic and relevant knowledge, etc., are rejected, and my learned friend is right. That only would, but it never did because it never happened, would act to the point where the decision is then transmitted up to the directors, But the directors, in order for the TA to have been, or any other disposition to be properly made, would then have to approve, and then it will come back down again. So in relation to this particular style of transaction, it doesn't set aside Geomatic. What it does is it puts an additional element of what is required before this particular act in relation to property is done. Does that help, or I confuse matters by giving a...
Well, it seems to be the geomatic principle effectively means that the directors can be bypassed.
No, the geomatic principle means that a decision that can be done and made by a meeting ordinarily by its members can be made if the requirements of that resolution were not formally done, and so geomatic effectively cures those problems. The point is, even if geomatic did cure the issues which have come about because the meeting wasn't, the resolution wasn't passed properly, it is only therefore a decision by the members that is made. And in order for the decision to be executed, it has to be executed by the directors. Geomatic does not bypass that requirement that the business of the company ought to be done by the directors. And I'll take you to where that comes out in the constitutions of the company. So all that Geomatic is doing is it's resolving what is below that waterline, the decision coming up to the directors. But then the directors still have to execute the business of the company. And that's the bit that's missing. What's happened effectively on the thesis that my learned friend proposes is that Abdullah, in purporting to be empowered by Muhammad and Majid, has created the tenancy agreement himself, i.e. bypassing the directors. Geomatic does not permit him to do that. Saban confirms that the process is the directors must make the decision, which is why I said it's fatal. And Saban also confirms that in order for this to be done, i.e. a transaction, a disposition, Article 80 bites. And the requirements of Article 80 are that sale, lease, exchange or disposition must be approved by the directors. And when it is approved, it then goes back down to the shareholders again to be ratified. So that's why Saban is fatal on two bases. It establishes the point about the business not being done by the members, but have to be done by the directors. And it also establishes the point that on this occasion, the directors have to make the decision and then send it back down to the members again. So you cannot cut out the directors. Is the simple point, and that's what Saban establishes. And the first thesis is precisely that. Igpl are trying to cut out the directors, and the reason why the directors need to do the business of the company is because that is what the constitutions say. So, and I'll take you to that. It is page 874, which is the second half of the bundle. So it's bundle 2, 874.
Yep.
Article 62, the business of the company shall be managed by the directors. And the paragraph goes on. It does go on, and it says other things, and I will come back to what it says. But the fundamental point I'm making is this, and it is fundamental. The business of the company, and this is the same with all three companies, the business of the company shall be managed by the directors. Shall be managed by the directors. Duomatic does not bypass this. Duomatic says, fine, if there is a decision made by the members and it wasn't done procedurally properly, as long as it's unanimous and as long as it's done with full knowledge and consent, if those requirements are met, then that decision made by the members may be carried as a resolution. And that is the power which has been donated by Mohammed, i.e. he's been donated the power over Mohammed and Majid's shares. That's been donated to Abdullah. And the power that's been donated to Abdullah, or Mohammed and Majid's rights attached to those shares, i.e. the ordinary rights, including to make a resolution. So, donated by Mohammed and Majid to Abdullah, power to make a resolution. That resolution needs to be made in a particular way. It wasn't made in a particular way, but my learned friend says Duomatic cures that. We say Duomatic doesn't, because full knowledge was not known by Mohammed and Majid, as per the evidence I've taken you to read the affidavits. Even if I'm wrong about that, and that resolution can be carried, that resolution in and of itself is insufficient to give Abdullah the power to create the tenancy agreement. That is because the power to create the tenancy agreement is business to be done by the directors, not the shareholders, the directors. And in this case, the directors were a different group of people. Plus section 80, which I've taken you to, specifically in relation to dispositions of land, that is a decision which must be taken by the directors and also passed down to the shareholders. But Article 80 bites.
Yep, I understand the reasoning. Thank you.
And just my learned friend says in response to that, well, hold on a minute. How does it effectively this? How does a shareholder create the business that control the business of a company? Because shareholders are entitled to conduct the business of the company. Even if it's bad business, they're entitled to conduct the business of the company. The answer to that is found in the rest of this paragraph, because the directors who have various powers, and those powers are set out there. And then it says in midway through the paragraph, and to such requirements that may be prescribed by a resolution of the members. Answer to my learned friend's query, well, hold on a minute. The shareholders should be able to determine how a company proceeds. The answer is they can do if they make a resolution. And the resolution then goes through the process of having to be prescribed, and the conduct of the directors then has to be prescribed by the resolution of the members. But what a shareholder's power does not do is allow the shareholders to effectively pass their own resolution and execute their own resolution as if they were the directors. And that's the fatal flaw in my learned friend's construction, by saying that the POA, the 2008 POA, allows Abdullah to create the tenancy agreement. What he's actually saying is this: that it's the wrong complaint. That's not this claim. What my learned friend is actually saying is this: look, I am Abdullah, and I have made this decision, and therefore it needs to be executed. But that's not a claim for specific performance. that is a claim that must be made by Abdullah against the directors for not carrying out his resolution. The
Sorry,
directors
start that one again for me.
Yeah. What my standing back, what my learned friend is saying is this: look, Abdullah was properly authorized to do this, to make this decision to create the TA. I have views about that, but let's, for argument's sake, Abdullah was properly entitled to make this decision. He made it. He didn't send it to the directors. The directors knew nothing about it, and this is plain from the matters traversed in my skeleton argument. The directors did not know about the TA. No one knew about it. It was a secret. But my learned friend says Abdullah still made that decision, and he was empowered to make that decision. So it should be applied. The TA should be valid, and it should be executed, and it should be applied. But that debate, that form of relief which my learned friend would be asking for, would be Abdullah saying this TA should be executed by the directors. So I'm seeking an order for this TA to be executed by the directors. But that's not this claim.
I don't understand that at all.
I'll try again.
Doherty is saying that Abdullah had power under the power of attorney to do what Majid and Mohammed could do.
Correct.
Question then is, what could Majid and Mohammed do?
Correct.
He says, as shareholders, they could decide to grant these leases. That's correct. That's his simple position. I think that's different thing, different animal to what you're trying to attack.
Well, that's precisely the position. My point was this, and is perhaps I don't need to go down this road, but my point is this: if the complaint is that the decision by Abdullah should be executed by the directors, then that's a different form of relief. That's my simple point. That's my simple point.
I don't understand. That's not what his argument is, at least not as I understand it. The question, what you have to attack, assuming that the power of attorney gives Abdullah power to do what Majid and Mohammed could do, is what could Majid and Mohammed do?
Yeah. Yes, that is precisely it. That's precisely what I had to attack. So therefore,
put it again in those terms, please. The one that you were just trying to put to me, which was talked about what Abdullah could do. That's not the question. The question is really what Majid and Mohammed could do. Put your argument in those terms.
Yes, and the argument is as expressed. Mohammed and Majid can only do what they only have rights as shareholders. Those rights include the making of a decision and the passing of a resolution. That resolution needs to be executed by the directors as per the constitutions of the companies. That wasn't done. That was bypassed. Instead, what happened is Mohammed and Majid, stroke Abdullah, executed their own decision. And that cannot be done in terms of how the constitution of the companies work, or indeed is not the law. I won't trouble you with what I was going to say, other than to identify that if the complaint was, well, we made this decision, so it should be done, that's a different form of relief. That was the point I was making.
All right.
And I was going to go on to explain why, but that is unnecessary, because the point of attack, as Your Honour has quite rightly said, is the question. The question is, does Mohammed and Majid have the power to make this tenancy agreement as a binding contractual document on behalf of the companies? I say no, because of the reasons which I have traversed as illustrated in Saban, plus of course the requirement of Article 80, which has been set out. So that's why thesis number one does not work. Again, it would mean, if my learned friend is correct, that where you have a company that has a different set of directors, are different persons than the shareholders can get together and make a decision, not have to tell the directors what they've done, and carry on the business of the company as if they were a shadow board of directors. And all the while, the directors will be carrying on the business of the company as directors, and not knowing the decision that the shareholders has made, ostensibly holding themselves out as controllers and managers of the company. And that's not what the Constitution says. That's not what happens when you divide shareholders and directors. And that is a consequence of having offshore entities where the controllers of the offshore entities are not the same as the shareholders. If it was a small ordinary company, any decision carried by the members can be done by the directors who are the same people. So that's where we are in this particular position.
But an offshore company is not critical to this. Let's say you have an entirely English company with two shareholders, A and B, and two directors, C and D.
Yeah.
The question is, what does Duomatic say those shareholders, C and D, can do? Your proposition seems to be that they can't do anything without going through the directors A and B.
Yes.
That you say, do you say that Duomatic does not allow that? In that case, you need to explain to me what you say Duomatic does allow.
Duomatic effectively ratifies a decision by the members that could be passed if the requirements of a member's resolution have been properly complied with. So it cures the defects effectively.
Well,
so
does that mean that you then say, well, what precisely could the members have done? And your position seems to be all the members could do is pass a resolution requiring the directors to grant the lease.
Correct.
They could not themselves pass a resolution granting the lease.
Correct.
That's your point, isn't it?
Correct.
Okay, I understand that. I think it's taken a little while to get there.
Yeah, that's precisely the point. So that's the first thesis. The second one is what my learned friend says alternatively, that put to one side the POA and the grant of authority via the shareholders, that in fact Abdullah was empowered to make decisions on behalf of the company because of various forms of authority that he was given by the directors of the company. So route one is through shareholders, route three is through directors, and route two through the directors is the way that the claim was put in pleadings and in evidence. And this is what I've concentrated on at length in my skeleton argument. And forgive me, the first thesis wasn't properly explored in my skeleton because that is something which has come about anew. The second thesis, what authority does Abdullah have via the directors of the company, again, is something which has been properly explored. There are three species, as I've said in my skeleton argument: express actual, implied actual, or ostensible. And I can sweep it away quite quickly in this sense. It's not express actual, because everyone concedes there's not an express POA by the directors of the company that was given to Abdullah for Abdullah to be the agent of the principals. And I cited an example of that, where there is an express POA, which was given to counsel in the UAE in respect of other proceedings. I won't take you to it other than to make the point that an express POA is done by deed in a particular way. But both parties agree that that is not what is being pursued here. So it's not express. It's not an express actual authority. It can't be, I say, ostensible authority for the reasons which I hope I've set out fairly at length in my skeleton argument.
Yes,
no representation made by the principal, etc. No estoppel, etc., etc. So I won't trouble you, Honour, with that again. I've dealt with it, I suggest. Right.
I think that, as you say, the matter we've been discussing so far was rather new, and I can understand the need to go into it more orally.
Yeah, that's precisely it. But so I can take this, may I suggest, just by highlights, and that's as follows. Really, thesis 2, what IGPL is saying is that Abdullah had implied actual authority because it was apparent to him. This is where the use of the word apparent is slightly conflated. It was apparent to him that he could act on behalf of the directors. So that's effectively what it's saying, but that is implied actual authority. It's not express and it's not ostensible, so it's got to be implied. The problem with that is that it needs, for it to be implied actual authority, a relationship between Abdullah and the principals, the board, which would give rise to that implied relationship. But there is no utterance of any word or suggestion between Abdullah and the principals. When I say principals in this sense, I mean the directors as principals. And that is a fatal flaw in my learned friend's proposition. You can't have implied actual authority if there is no relationship between the putative agent and the principal, and that's the difficulty. And I can distill it down to 4 points, which shouldn't take too long. The first is this: it doesn't matter if it was apparent to Abdullah that he could be a general agent with whatever power he wished to bind the BVI companies. That's not the test. The test is whether there was the existence of consent and an agreement between the principal and the putative agent, such that implied action authority can exist. And it must be particular to the issue. So it must be implied action authority to agree and consent and negotiate the terms of the TA, tenancy agreement. And it must be donated with the attendant fiduciary duty of complete loyalty to the company. Otherwise, it wouldn't be known. And so Your Honour will recognise that the difficulty that Abdullah has is that he's sitting on both sides of the table. So point 1, to reiterate, must be existence of consent and agreement on the particular matter upon which the putative agent is dealing with. Point 2, it's that the implied authority must be appertinent to express. And there's no express authority agency relationship that exists in this case. As I said at the beginning of this section, there's no suggestion of an express authority, that a power of attorney that was granted to Abdullah. And this is where both of us agree that the leading case is Healy Hutchinson. And both of us have relied on Healy Hutchinson in our skeleton arguments, but we take different views. What I say about this is that if you look at Healy Hutchinson, it's 100 miles away from where we are at the moment. The agent in that case, where applied actual authority was said to have existed, had an extremely close relationship with the remaining parties to the matter. He was the managing director. And really what Healy Hutchinson says is that, well, look, he had an express relationship of authority because of his position on the board. It was implied by the behaviour and consent of others, and we can read into that, into the facts and circumstances that it was applied, that implied consent was given for that person with express authority to do this particular task. But what Healy Hutchinson demonstrates is that you need the underlying relationship of a power that must exist before you can then say, well, was it implied from that relationship authority will be granted for this particular task to be done? To put it much more simply, you can't have implied actual authority if you are a stranger to the boards. And that's something I've said repeatedly in my skeleton argument. That is the appertenent point. And the law is quite clear. That implied actual authority must be appertenent. Can't be standalone, can't be a stranger to the board. And that's not what we have in this situation. He's a corporate stranger. Two minor points. Silence is not enough. You can't imply through silence that implied actual authority was given. The law is clear about that, and that's MVV. I've dealt with that in my skeleton argument. And the law is also clear that there must be a direct line of consent to the agency relationship which flows down from the principal. And this is why I say you can't look sideways. Implied actual authority requires that there be knowledge and a subscription to that relationship, albeit that the conduct indicates that that was implied by those who are involved in it. But it must come from the principal. You can't look sideways. And the reason for that is because the duty of loyalty that passes down into an agency must come directly, must come vertically. It can't come from left to right, i.e. he can't look sideways. And the whole aspect about what my learned friend is saying, that the source of the authority was because he looks sideways to others, doesn't work. That's point 3. There must be a direct line of consent and donation of authority between the principal and the agent, must be vertical. And point 4 is a simple point, but it's stark. There is good reason for the requirement of consent and appertenency, and that is you can't have self-appointed agents acting in secret without the knowledge and consent of the board, because that will be commercially chaotic. And this case epitomizes that. In other words, and standing back, this tenancy agreement was done by Abdullah without the board's knowledge, and therefore rights and obligations were created by Abdullah, ostensibly, that bind the companies. The companies knew nothing about it. The companies went on their ordinary business, including granting leases to other individuals and extending leases as well. And that is an illustration of the commercial chaos that would ensue if my learned friend's proposition that you can have a self-appointed gratuitous agent, such as Abdullah is suggesting, takes place. And so that's the stark reality of what I say. The reasons why direct line consent and appertenent must exist in terms of implied actual authority. So that's in summary what I respectfully suggest I've set out at perhaps rather painful length in my skeleton argument when I've explored each species of agency, and why I say it does not work that where Abdullah to be an agent of the directors.
Yes, all right, I follow that, thank you.
Yeah, and so can I wrap up the point about agency? And it's this: 1, IGPL's case it legally doesn't work. 2, it's changed. 3, theory 1, that POA usurps the board of directors is wrong in law for the reasons I've explained. 4, theory 2, that a POA, an agency can be granted by implication via the directors, can't survive the fact that Abdullah was never given express authority, and that is and that what's being suggested was not appertenent. And 5, in all of those premises, and this really comes down to the issue of immediate judgment, the notion that something might turn up to fundamentally change the shortcomings that I've identified from now until trial is utterly fanciful. Either it works or it doesn't. And I take your Honour will be very familiar with the phrase whether something comes up which would be it's fanciful to suggest that something will come up, because that is the basis upon the authority review which you did in GFH. But there isn't anything that can turn up that's going to change these fundamental issues to do with the problems in law with authority. And again, I make the observation, which I did at the beginning. Which authority is it? How did it work? The person that can answer that is Abdullah. He's not graced us with training the boards to explain exactly how his authority thesis was, what authority he was applying, and what's happening really is that Igpl is speculating onto what he could have applied. But when they do speculate, none of it works. So that's a position on that. That leaves authority, both new and old proposition. And the next section that I was going to deal with, which will take less time, is sham.
Right. How much time do you expect?
Hopefully I'll do it within half an hour, 45 minutes. That's council's estimates, though.
Yes, indeed. As a rule of thumb, double it. That is not an invitation to do so.
Well, I wouldn't take it as an invitation.
I think we've been going with our initial difficulties something like an hour and a half, I think.
Yeah.
Let's take 10 minutes break now.
Yeah.
And finish that off. Please make it more like half an hour than anything else.
I'll try my best.
Because again, you have dealt with it quite extensively in your written submissions.
Yeah.
And then Mr. Doherty can set two. So we'll take a 10-minute break now, I think.
Yeah.
Is that all right, gentlemen?
Thank you very much.
Yes, Your Honour. Thank you.
How's that?
Yes, I can now.
Right. Mr. Doherty, can I hear you?
I hope so, and I can hear you.
Yeah. All right. Thank you, Mr. Osmond. Please continue.
You want Sham? Can I take you to the law bundle, please? Page 390, Midland and Ohio.
Yep.
I've taken you to the conclusions. They are as really comes down to this. This was an issue as to whether a trust deed was said to be a sham or genuine. And the way the court approached it is to look at what was done with it. It had various terms, and if it was genuine, then those terms would be carried out. And if they weren't, then that would lead to the conclusion that it was not sincere and ingenuine and had another purpose. And so the top of 390, the judge explores what was done upon the creation of the deed, and says, I won't take through every paragraph, but says it's quite clear at the time of execution, Mrs. White wasn't aware of the import of effect. And then he goes on to say that effectively no one else was aware of it and no one else knew about it, did anything, and it wasn't done. And so the conclusion to all of that is at the bottom of 390 at I, where it said, I do not believe that Mr. White had any intention when he executed the deed of endowing his children with his interest, etc., which was his only asset. I consider the deed was executed by him, but not acted upon to put in the safe for a rainy day, hence the phrase rainy day agreement. Mr. White said that it was to safeguard to protect his family from long-term commercial risk should he set up his own company. As such, I consider the trust was not what purported to be, but a pretense, sometimes referred to as a sham. And then this, slightly further down over the next page, which is 391, it follows that even if the deed was entered into without any dishonest or fraudulent motive, but was entered into on the basis of mistaken advice, in my judgment, such a transaction is still void and therefore an unenforceable transaction if it was not intended to be acted upon, but was entered into for a different or ulterior motive. Accordingly, I find the declaration of trust sought to be void and unenforceable. Therefore, the language that I have used in my written submissions, rainy day, ulterior motive, is founded upon the approach taken in White and Midland, and so too.
Hang on a sec. Can I just understand where we're going here?
Yeah.
From the rainy day approach, the agreement for lease was entered into in 2013, just in case something bad happened to the Al-Sari business interest. In other words, it was genuinely entered into on that date in its terms, albeit not intended to be acted upon. That is different from the proposition that it was not entered into in 2013, but was bodged up sometime in 2019 or 20, once the judgment had been given against the Al-Saris, in order to frustrate enforcement of the judgment. They are two different things. Which is your case?
For the purposes of immediate judgment, I cannot establish when the tenancy agreement was created. There is evidence via the freezing orders, because they were not mentioned in the freezing orders, that it was done in 2013. However, as to whether it is a sham, the point is it was clearly done in order as a protection device. Whether that was done in 2013 or whether that was done later, the function of the document was for it to be a rainy day document. And that's how I put the case.
Right. That I must say that's not what I had understood was going to be your case, and perhaps I have been influenced by, as I should not have been, by Mr. Fedrigoli's affidavit, but I understand what you say, by his witness statement, I beg your pardon. Mr. Fedrigoli seems to take the high, wide and handsome approach.
Yes, I mean the proposition there, and it's not a proposition which is necessarily inconsistent. The proposition there is that this was a document that was created in order to stop enforcement. The question becomes whether it was done at 2013 at the time, or whether it was done later. There is evidence to suggest via the freezing orders and the fact that it turned up in 2019 that it was done later. We don't know when it was done because the only person who knows when it was done was Abdullah, and we don't have any assistance from him. But what I am trying to do is to demonstrate that the function of the document, whensoever it was created, was in order to prevent, was in order to keep the Al-Saris in permanent occupation of the premises, come what may, if there was ever an attack by a judgment creditor. And so if I'm able to establish that, I say, I'm able to establish that it's a rainy day document. And if I'm able to establish a rainy day document, I'm able to establish sham that comes on board. So if there is a difference, it's a difference on the unknown question as to when it was created. But what I am doing here is seeking to demonstrate that what matters is what the function of the document was.
But there is a big difference in what one may pay regard to in order to decide whether or not it is a sham in the sense of a rainy day document.
I will refer to the fact that whenever it was taking IGPL's case at its highest, it was done in 2013 for the purposes of immediate judgment. I would look at that to say, well, if it was done in 2013, what was done after it was said to have been created? And what was done after it was said to have been created is frankly nothing. It just sat in a drawer, to use a colloquial term, and I'll show why. And that's the proposition which I can make good at this stage. Mr. Federigoli does go on to say it appears that the date of the tenancy agreement was not 2013, and the reason why is because it doesn't appear in the affidavits. It only appears in 2019. But in terms of, again, why it was done, when it was done is not as consequential as why it was done, and why it was done is the same whether it was done in 2013 or done in response to what CBD, Commercial Bank of Dubai, had done in terms of obtaining its judgment relief. So if there is a difference, it's the unknown date of when it was created, but that doesn't detract away from the sham nature of what the tenancy agreement was all about. That's the way I put it. Okay,
thank you.
So again, Wyatt, there are two questions that then come up. What was done effectively, and if nothing was done after it was said to have been created, does that indicate that in fact it was there as a protective device? And so, can I look at that first aspect? I've taken you to the affidavits, which was at hearing bundle 310 and 314. I won't take you back there again because you've seen them. The simple point is this: they were created in 2014. The TA was created in, or the date of the TA is 2013. If the TA was created in 2013, then it stands to reason that upon disclosure, under penalty of penal notice, etc., then it doesn't seem to make any sense whatsoever why that wasn't mentioned in those in that evidence. More than that, Abdullah was party to the English proceedings and therefore knew about the freezing orders, and there is reference to that in documentation, and I will give it to you. It's page 251 of the hearing bundle. But the point is this: he knew about them. He knew about them. And IGPL therefore knew about them because he is IGPL's manager. There does not appear to have been any attempt by IGPL to intervene in any of those processes in order to establish that they had a right and interest in the properties. And so,
well, what's your point as a result of that, though?
Sorry, I was just shutting the window. My point, forgive me.
What is the point you're making from the fact it was not disclosed when, according to your submission, one would expect it to have been?
Number one, in describing the nature of the properties and any encumbrances, it should have been disclosed. And if it wasn't disclosed, then it wasn't acted upon. And number two, if IGPL had genuinely thought to establish that it was had genuinely thought to apply the terms of the tenancy agreement, it would have sought a variation of the freezing orders in order to register the leases that were said to have been created by way of an agreement to create the lease. And that's
well, this is where I don't understand where you're going, because surely if it was a rainy day document, the rains had come in 2014.
If it was
brought out and waived it.
If it was a genuine my position is this: if it was a genuine document, then it should have been applied as a genuine document when the terms were created.
But if it was a rainy day document, that was the time for it to be brought out. It seems I cannot really quite understand why you are putting it as a rainy day document. It seems my present thinking is that you either have to go the whole hog and say that it was a complete sham in the sense it was later created, or you don't.
I think that the difference between I'll make it as clear as this. This was a sham. It was not a genuine document. We don't know when it was created. It was created in order to stop enforcement. We're unable to say whether it was done in 2013 or afterwards. The evidence tends to indicate that it was done after 2013 because it wasn't included in the affidavits, and it didn't turn up until 2019. What I'm trying to establish is that if it was a genuine document in 2013, things would have been done. That's really my case.
Right. Well, this does not look like an immediate judgment point, to be honest, Mr. Osman.
Can I make some submissions?
Well, by all means, but I think I should make known to you that it does not have that immediate attraction.
Yes. Can I make some submissions on this basis then? And focusing, and I hear what your Honour says. I hear what it says. But what I want to focus on is the key question as to whether it is genuine.
Mm.
And if it's not, that in my submission is the end of it. And there are three aspects.
So genuine meaning what?
As it was a genuine commercial agreement between the parties.
Right, thank you.
And there are three aspects as to why it was not, we say, demonstrably a genuine agreement between the parties. Price, consideration, and paid stroke rent, and the extant leases over the commercial properties, which is suites 2 and 3. Price. What we say is that the whole arrangement was put in place, the terms of the tenancy agreement were created so that our Saris wouldn't have to leave if they lost control of the BVI entities, and 2, that they wouldn't have to pay for any further occupation at the end of the 15-year current purported term of the lease. This is, and Your Honour may remember it, this is an issue which you raised during the hearing of the injunction application.
Yes, I remember raising what happens what do they have to pay for the renewed term. I don't think I got a particularly good answer, but my recollection may not be good.
I'll give you, I won't take it to you for the interest of time, but I'll give you the reference in the bundle. 1, 2, 3, 4. 1, 2, 3, 4, which is the transcript. And you asked the question, one assumes, forgive me, Mr. Doherty responds, one assumes it could be in the 850 ballpark. That was the answer. With due respect to him, he's wrong about that when one looks at the TA. And the reason why he's wrong is actually set out in the evidence. The point is this: as Ms. Sheffield calculates by reference to the amount of service charge that have been paid up until from the time of the tenancy agreement's creation until December of last year, it was £333,000. Over 15 years, that will be 625,000. The terms of the TA include an offset of income in respect of income from the freehold and the various other interests. And so that income, we say, put together with the service charge over a period of 15 years, would, by reference to the terms of the TA, be applied to future rent. That's what the addendum does. And so when one applies those numbers, then there would be an offset of the service charge and other income from the freehold, which would mean no further rent would have to be paid. That's the purpose of the addendum to the tenancy agreement. It's to create that scenario. So where you asked the question, well, what would happen after the end of 15 years? The point is that no further rent would have to be paid. The terms of the agreement also stipulate that it is to be extended upon the discretion of the tenants. Putting that all together, the effect is, as I say, the Alsaris would be in, and there's no break clause, the Alsaris will be in permanent occupation for as long as they want, without having to pay any further rent. And we say that is a term which is indicative of the fact that it's not a commercial arrangement, but indeed an arrangement which is put in place to allow for perpetual occupation, even if the Alsaris lost control of the underlying BVI entities, which is precisely what's happened.
When you say perpetual, my recollection may be wrong. I thought that the structure was a term of 15 years and an option for renewal for a further 15 years. So it's 30 years all told, not perpetual. Am I wrong?
15 years, extendable for another 15 years upon the discretion of the tenants.
Yeah, well, that's not perpetual.
So I've used the wrong word, but it's a mechanism which has been put in place to allow 15-year stints extendable by the tenants. No break clause.
So 2 15-year stints.
If at the end of the second year 15 stint there needed to be another extension, then the terms would allow another extension after 15 years.
That is not my recollection. It may not matter, but I'd just like to see if I understand it correctly. Are you saying that it was not 15 plus 15 and no more? Are you saying anything further than that?
I'll read the term. The term of tenancy commences on the 16th of January, will continue for 15 years. The term may at the option be renewed for similar terms thereafter, or on the same or similar terms as those currently provided in this agreement. Should the tenants wish to exercise such an option, they shall serve a written notice on the landlord, etc. My reading of that, and it's at core bundle 13, it's Article 4 of the tenancy agreement.
No, hang on a second. I've got a copy here. I see what you mean. It does say renewed for similar terms, plural. Yeah. Right. Okay. That was it's my fault, Mr. Osman. That was not in my mind.
No. Well, then I did explain.
I can see. I can see a question there.
Yeah. So anyway, but the point, I think your Honour's got the point. The point is that this is a mechanism. Is it commercial? No, it's not. It's a mechanism which will allow the Alsaris to stay if the underlying companies. Well, and that's what's happened. CBD now have now owned via a subsidiary the underlying companies because of the enforcement proceedings that have been taking place in the BVI via the receiver. So that's the first point. But reasons as to why it's not commercial. Price itself, 850. Well, 850, as we all know, was required because that was the monies that was needed to discharge the outstanding mortgage on the premises. Is 850 the price, the right price? My learned friend says, well, you've adduced no evidence about this, but the evidence is perfectly plain, and that's this. The leases and the price of the leases over suites 2 and 3, I've done the calculation. Over 15 years, just for an underlease in relation to suites 2 and 3, over 15 years is £2.9 million. Of course, this tenancy agreement includes flat, underlease suite, income from the freehold, because it involves all 3 companies. So income from freehold, flat, plus underlease in relation to suites 2 and 3, 850 as opposed to the commercial, already in existent terms of under leases for suites 2 and 3 to HCA International, a currently occupying tenant over 15 years equates to £2.9 million. So it's not an Arnold position where the court can't determine whether the bargain was a good bargain or a poor bargain or whatever it may well be. It's beyond that. It's unconscionable price-wise, and was plainly fixed in order just to discharge the outstanding mortgage over the properties and not having to pay a penny more. On the mortgages point, my learned friend makes the point that, well, that was plainly consideration because the mortgages need to be discharged. But those were loans taken out by Mohammed and Majid that he had to pay back by that year. So the question then becomes, was the arrangement for 850 there to pay off the mortgages and to call that consideration? Or was it a genuine price to pay for the deal? We say absolutely not, because when we looked just at suits 2 and 3, the price for suits 2 and 3 is £2.9 million over 15 years. And so it wasn't commercial. And it was done for an alternative purpose. And the alternative purpose was to use the monies that had to be paid to pay the loan back in order to demonstrate that that was consideration, and use that consideration as consideration for this purported tenancy agreement. I'll give you some references. I won't take you to it. The reason why it's 2.98 million, the evidence of that is found at pages 1052 to 1054 of the hearing bundle. I don't need to take you to it, but that's the basis for the calculation which I've done. And it's a contrived and artificial price, as I say, which is not in any way, shape or form the position in Arnold, which suggests that the court should not look into commercial deals between the parties because a bad bargain is a bad bargain for the parties. It's not contrived. So that's in relation to price. Consideration of rent paid, which is not price, but it's consideration. This is the issue to do with the £400,000 paid by IGPL. And the truth of the matter is this. In Ms. Sheffield's first witness statement, she explains that £400,000 was paid by IGPL for consideration, £450 paid by Mohammed. So there were two elements of the price for consideration paid, and she goes through that. She says this is the transaction which shows that 400 being paid. In support of that, there is exhibited bank account details and debit advices, and one day is produced. Your Honour may remember this. You may remember being taken to a bank account statement which showed £400,000 being remitted to Hortin Holdings. But that was the day it was done, and it was indeed it was pleaded in my learned friend's skeleton argument for the injunction that £400,000 was paid, and it was averred during the injunction that it had been paid. But what has now become clear from Mr. Clune-Denver's evidence, that in fact, on the day of the tenancy agreement, the 13th of January, or rather indeed the next day, efforts were already underway to reverse that money. And 7 days after the £400,000 was paid by IGPL, it was reversed and given back to IGPL again. What's the point of all of this? It's not just gratuitous by me. The point is this: the tenancy agreement, that you may still have it up. It's page 13 of the core bundle. Paragraph 6 says, prior to the date of the agreement, the tenant IGPL LLC has paid a sum of £850,000 on behalf of the landlords for settlement of certain loans taken by the landlords from Coutts in order to release the mortgages on the properties. That was on the 16th of January 2013. That was not correct, because at the time, the very next 7 days after it was being paid, it was being reversed. If one looks at the addendum to the tenancy agreement, which is at page 20 of the core bundle, the first recital says the rent paid by the tenants to the landlord is in full and final settlement of the rent and any other sums whatsoever due and payable by the tenants in relation to the use of the properties. That addendum was dated the 4th of March 2013. So that cannot have been right, because IGPL knew that the money had been reversed. My learned friend relies on other payments made by other parties, a company called Layer Holdings and various other individuals, say, well, that payment may have been reversed and we may have said something different. Now we know it's reversed. We don't know why. Now it's reversed. Don't worry about that because other payments were made by other companies. Well, that may be correct insofar as a matter of fact, but they were done after this addendum was created. So at the time of the addendum, IGPL hadn't paid had paid monies but had reversed those monies, and there'd been no replacement monies. But yet that's what the recitals say. My point is this: no genuine commercial arrangement would have made that declaration of monies paid when it was not the case. And no genuine commercial arrangement would have entered into an addendum to the tenancy agreement, which created a right to offset the income if IGPL hadn't paid its consideration, which they said they would have paid and did pay when the tenancy agreement was created. In other words, it's contrived. And if one takes it from the perspective of what ordinary commercial actors would do, it cannot possibly be the case that an agreement would have been reached on these terms if the factual basis is the money had not been given by IGPL because it had been taken back by them instead. Can I take you to one particular document about this in the hearing bundle? And it's one I do want to take you to, and I'll do it briefly. It's 1176. It's in part 3.
Page again, please.
1176.
Good. Yes, I have it.
This is a witness statement that was tendered in support of the Part 8 claim, which is given by IGPL's finance manager. It's the first and only time we've seen any evidence from IGPL. And it says, and it's the sentence I want to take you to is at the bottom, paragraph 6, the second payment on the 13th of January 2013 was for 450,000. Sorry, forgive me, paragraph 5. The first transfer was on the 8th of January for the amount of £400,000 IGPL to Hortin. Yes, that payment was made. And then 6 talks about the 450. 7 says both transfers were unhindered and successful. The copy is very bad, but that's what it says. And this statement is signed in July 2019, 6 years after the reversal. My point is this: it's not genuine. This whole arrangement is not genuine. And what is being done here is an effort to show that IGPL had paid money, but to hide the fact that the money had been returned. And that untruth was being still perpetrated in 2019 in evidence. And if this was a commercial arrangement, A, the terms of the addendum TA would not be as they were. B, the presentation of this 400,000 payment from IGPL in the way that it has been presented in the Part 7 and Part 8 wouldn't have been done. And the reason that those aspects are being done is in order to create a standing by IGPL to say that they have paid consideration. Your Honour will recall, having read the submissions in relation to whether IGPL can bring the claim, that part of the consideration for why they can is because they have paid consideration and so are a co-promisee. On the face of the material, they haven't paid consideration. My learned friend's answer to that is, oh, others have paid, and that counts. But there is nothing to suggest that those monies were for consideration of the TA as opposed to the discharge of the mortgage and loans on the property. So what I'm effectively saying is this: there isn't any evidence of consideration. There might be evidence that the loans are being discharged, but more primarily for the purposes of commerciality, the suggestion that consideration was paid in the TA and addendum TA was just simply incorrect. And on that basis, it cannot be, I suggest, that the tenancy agreement was genuine, because if it was a genuine tenancy agreement, then those terms would not have been signed up, because they just weren't right. So that indicates, in fact, that it was indeed, as I say, an indicator of sham. So that's in relation to consideration. I've dealt with price. My final aspect in relation to sham is the leases. Now, I say that the leases is probably the most straightforward evidence that the BVI companies, A, knew nothing about the tenancy agreement, B, were doing that the shareholders were on a purported frolic of their own, creating encumbrances on the property without the directors knowing about it, and C, that the terms of the tenancy agreement were not commercial, were not bona fides, and were in fact not as the document says that it was, i.e. a sham. And I don't need to take you to every single lease, because again, I've dealt with it at some length in my skeleton argument, but here are the highlights without taking you to the documents for the purpose of saving time. Westdean had leased Suite 2 to HCA, a completely different company, nothing to do with the Alsaris at all, for 10 years in 2006. Westdean had sought the consent, rather the directors of the company had sought the consent of the Commercial Bank of Dubai to vary the freezing order to allow the Westdean to HCA lease to be extended up until 2006, past 2016. And that was done as a deed. Point. Before the TA was put in place in 2013, the suites were already occupied. After the TA was put in place by 2016, the directors were working under the restrictions of the freezing order, but with HCA to create further leases over the same suites that the tenancy agreement here suggests had been sublet to the Alsaris, to Igpl and the Alsari natural persons as well. The point is this: it's plainly a document that was existing in the ether somewhere without the knowledge or understanding of the directors, and in any event could not have been genuine, because it was impossible to perform, because there were leases already in relation to those commercial units, and impossible to perform lease is not a genuine, impossible to perform agreement is not a genuine agreement. Ergo, we suggest it's a sham. A couple of other points, and only a couple of others. The price for those leases over those commercial units is £648,000 just for that one suite, again for that term. So just that is the vast bulk of the consideration that was purportedly paid, 850 for all head lease freehold flats and under leases as well. What's Igpl's explanation to the existence of the extant leases and the tenancy agreement? Well, there doesn't appear to be one, and the irreconcilable nature of those leases and the inability to explain those leases over the other suites is, I suggest, absolutely firm evidence about the fact that the tenancy agreement was simply not a commercial arrangement. The indicators are, and there is sufficient, which is why I wanted the attempt to persuade you out of your position with respect, Your Honour, but their indicators are strong that in fact this was an instrument that was designed for an ulterior purpose. and that is to keep the Alsaris in occupation permanently without having to pay an extra penny. And the mechanisms taken together allow that to happen. Where Your Honour has challenged me to say, well, when do you say effectively it was done? Was it done as a pre-thought in 2013, rainy day, or was it done after as a reaction to CBD's enforcement activity? For the purposes of immediate judgment, respectfully, I say that is not the issue. The issue is, again, whether the tenants agreement taken together with all the terms and in all the circumstances was a genuine commercial document, or did it have an ulterior purpose? And we say that it's absolutely plain whenever it was created, it had an ulterior purpose. So
hang on a second. Now, what is the ulterior purpose?
To ensure that if in the event of the BVI companies being subject, losing them in some way, whether they're attached to judgment orders or some other way, that they can be owned by someone else. And in this instance, it's CBD, that's what's happened. But the Alsaris would never have to leave because of the tenancy agreement, and they wouldn't have to pay in order to continue to occupy the premises via the tenancy agreement. And so,
yeah. Well, this is where I do have difficulty.
Yeah.
At an immediate judgment level, Mr. Osman, and I should explain it. Ulterior purpose can be postulated if the case is that there was a judgment in force, it was trying to be enforced, and this was bodged up in order to hinder and frustrate enforcement. Now, that's a good, solid ulterior motive which can be part of somebody's case.
Yeah.
However, if one says, I look at it as at 2013, then one has to say, well, the ulterior motive is not an imminent enforcement, but rather a just in case, the rainy day.
Yeah.
Was there any just in case around at that time? Was there a reason for thinking just in case? Can someone genuinely say, I've got nothing to worry about, I have no reason to think that I will lose control of the BVI companies, but I'm going to make darn sure that the Al-Sari family has the benefit of this place in perpetuity. So that's why I'll sign.
Yeah, and I understand that, Your Honour. And my response to that is as follows. What's the point of it? Because the Al-Sari family had been in occupation for many a year previously, and they've never needed a tenancy agreement. All of a sudden...
I'm sorry. Just let me finish. My point is that it seems to me rather difficult to say on an immediate judgment application which one of those it is.
I agree. At immediate judgment, I'm not going to take an unrealistic position. Of course I'm not. I can't say whether this document was done in 2013 or not. There is evidence which points to the real suggestion that it was not done in 2013. And I've gone through that. Freezing orders, 2019, then expatting, etc., etc. I hear what Your Honour says. Well, is that something I can deal with at immediate judgment? And I recognise that is a dispute which probably needs some evidence, etc. I understand that. But my point is this: it doesn't matter, because what has to be looked at is whether this document was a genuine document, whether it was done in the knowledge that CBD were chasing and that there'd been an attempt to stop them getting the properties, or whether it was done in the idea that they might lose the premises at one point, and therefore it was done where it was never needed before. And that's really the key. It was never needed before, and at the time it was done, it was done. And Mr. Coolin Denvers can't explain why all of a sudden this tenancy agreement was required. And of course, we don't have any evidence from Abdullah to say why he did it. But the point of the matter is this: when one looks at what the terms are, when one looks at the commerciality of it, that is the focus which I ask Your Honour to apply respectfully your mind to. And when one looks at the terms of it and how it operated, the intolerable conclusion is it wasn't commercial. It wasn't commercial. It was plainly a device in order to keep them in premises. And I hear what Your Honour says, that if my case would be much more elegant if I was able to say, that is when they were chased, that is what they did. Of course it would be more elegant. I can't do that at this stage at immediate judgment. I can't do that because it says what it says on the face of the document. I don't accept it's 2013, but I can only not accept it's 2013. But my case would be more elegant if I could say it's not a 2013 document. I have to go through a slightly more convoluted explanation and ask the court to really focus on the terms of the TA to determine whether actually it was a TA which was properly commercial. And when one does that in the way that I've done it, I suggest that it palpably is not a commercial document at all, and it was clearly a device. When it was put in place, I suggest it's not relevant for the purposes of immediate judgment. And that's my position. And then finally,
hang on, but it is not binary. You can have a genuine non-commercial document, can you not?
You can have a non-commercial document in terms of it's a bad deal. Yes, you can do. It's not commercial because it's just a poor bargain. I agree with that. But that's not this document. This is not a poor bargain.
You can have it as a document which is non-commercial, but with the genuine and unimpeachable, let's put it that way, purpose of ensuring that the Al-Saris have this place for as long as they like. And that back to the immediate judgment point. In order to exclude that requires fairly considerable inference. And I won't repeat it. My difficulty is whether that can be done even at that level on an immediate judgment application.
No, and I hear that. Look, and I'm grateful for the indication. Rather be able to engage with it now than having to deal with it later on. And Your Honour has my submissions, but I would add this very important point as this: all of the questions that Your Honour is asking, in fact, that both yourself and I are debating. Well, when was it done and why was it done? Those are not questions that the defendants can answer. We didn't know anything about this TA. It wasn't, and this appears to be the position really which the claims are settling upon. Abdullah did it by himself, and it's created. He can do it by himself. He could have done it by himself, and he did it by himself. And the evidence plainly points in one direction. He did it by himself and kept it a secret. That is a firm conclusion I respectfully suggest you can come to now. So therefore, why did he do it? Therefore, why are the terms as they are? There is nothing that we have that can speak to Abdullah's state of mind. But Abdullah can. And this is why at the beginning of my submissions, I referred you to, I think it's paragraph 40 of GFH, which is your frankly seminal decision, which has been adopted many times over in every single immediate judgment authority that's been put before these courts, where Mr. Hay, who was notorious, was not able to assist you at all with explanations that were cried out for, or there were explanations that were being cried out for. He didn't put himself forward. And my fundamental proposition is this: it cannot be right for Abdullah, who is the owner of this data and these explanations, to sit on the sidelines and say, I'm not going to help the court with the reasons why I did what I did, and for the defendants on that basis to be defeated on immediate judgment. He knows the position. He knows when the tenancy agreement was created in 2013. He signed it in his own name on both sides. Another reason why it's probably not commercial. He didn't put his name to it. We had to tease that out. And he's not come forward with any explanation as to what on earth was going on here. So all of the questions which Your Honour asks are questions for him. And the point is, if he has not elected to come before the court when the matter is being debated now for immediate judgment, it should not be right, respectfully, that the defendants are defeated by saying, well, he's decided to stay in the sidelines and has successfully done so. And for that reason, you can't get immediate judgment and you have to go to trial. So that's really where the fundamental point which we come to. I recognise all that Your Honour says. I push back against the idea that the matter can't be dealt with immediate judgment, and I hope that my explanations as to my thinking give some assistance as to why I say, in fact, on deeper analysis, this can be and should be dealt with now.
Yeah, I'm sure you recall that I was in fact reversed in the Hague case. They said I shouldn't have given immediate judgment.
You were reversed in the Hague case, but your Hague, the way the approach you took in Hague has been adopted in. There's a whole host of authorities which I refer.
Okay. Anyway, enough of that. All right, thank you, Mr. Osman. Anything else?
No, I just wanted to say one thing, and really I think it's because it's the rather convoluted way I've dealt with the first proposition. I'm not going to go back to it. But there is really one fundamental point that I've been reminded that I really ought to have made, and it's this. The power to bind a company vests with the directors only. And that's simply as that. I could have just uttered that in one sentence and would have probably done away with about 30 minutes worth of submissions. But that's the underlying point which we wanted to make in relation to that first aspect of authority. So apologies for being convoluted, and I hope that gives some clarification as to really where we go to on that particular point. But those are my submissions.
Yes. Mr. Doherty, from Mr. Osman's point of view that I'm not with him on the sham side, solely because I do not think it's something that can be properly say is an immediate judgment point. But I do want to hear you on the authority side of things.
Yes, Your Honour, thank you. I suppose in that case I'll jump straight into why the last comment that my learned friend made is wrong. And so I'll start with my submissions on authority, and you'll have seen my learned friend has already summarised that I put forward two sets of analysis in my skeleton, either of which we say get us home, not only when it comes to the application of the higher threshold test that applies an immediate judgment, but we would say on a balance of probabilities basis. I propose to take Your Honour through the points in a little bit of detail because I think it's important. Your Honour will also note that there are, as part of that, a few potentially quite knotty issues, particularly which could give rise to conflict of law issues. And to that extent, we say that the complexity of this issue is one which would also add to the myriad of reasons why this is not an appropriate case for summary disposal. But I'll start with my primary case. That's the one which is set out at paragraphs 54 to 60 of my skeleton. And in a nutshell, it's that Abdullah al-Sari, who signed the tenancy agreement, had the express authority to bind the BVI companies. And the first place I'd take Your Honour to in making that submission is the proceedings that have been before the Sharjah courts, which have already given some consideration to the question of Abdullah al-Sari's authority to act on behalf of the first to third defendants.
I don't particularly want to go there. I have to make up my own mind. It doesn't matter to me what the Sharjah courts have decided. I make up my mind on the evidence before me. I don't know what evidence was before that court.
Yes, I understand that, Your Honour. I suppose the premise for taking you there is that there are a number of issues which are built into the question of authority in this case, there are the arrangements as between principal and agent. There are the arrangements that relate to the interaction between shareholders and directors of companies, and then there are the arrangements which relate to the dealings of an agent with third parties. And there are cases where the law governing each of those steps can be based on a different set of law. So, for example, when it comes to the question of does Abdullah have the authority to act on behalf of Majid and Mohammed, that is a matter which the Sharjah judgment touches on and may well be relevant as a statement of what UAE law is on that point.
I have no evidence of different laws. Looking at the Sharjah judgment is not going to provide that evidence. If there is to be any such evidence, it should be in proper form.
Yes, quite.
Especially on the material I've got, not the Sharjah judgment, please.
Yes, it's safe to say, Your Honour, that you in some senses make the point that I was going to make, which is that where there are those crossover of issues, those crossover of potential laws, those potential conflict of law issues, that those are questions which quite rightly ought to be reserved for trial and not dealt with on a summary disposal basis.
That was not my point at all. Before me, there is no such question. No one has raised that question, including in your submissions.
Yes, sure. I take your point. I think the place where I'll leave it is to say that that added level of complexity is one which goes to the court's discretion when it comes to applying the test for immediate judgment. But I'll move on past the Sharjah judgment. You've read the witness evidence on that. You know what it says. The second document that I'd minded to take Your Honour to was the 2008 POA itself, which is in the hearing bundle at page 179.
Yeah, I have that.
Okay, wait, I'm just getting my own page reference. Now, my learned friend invited me to come to this document and explain what the basis we say for Abdullah's authority in this case is, and we can see immediately in the first paragraph that we have a donation of power from Mohammed and Majid to Abdullah, but in the second paragraph that it's described in very broad terms. It says, accordingly, you shall have the right to represent us and absolutely act on our behalf to buy, sell, buy, and accept the purchase of all kinds of movables, immovable properties, real estates, lands, vehicles, all other properties registered in our names, and all different types of establishments belonging to us in our capacities as owners and partners. And in the following page, we see that that includes, amongst other things, dealing with and renting properties and dealing with tenants. So that's the first full paragraph on page 180. He shall also have the right to terminate the visas of servants. He's entitled to endorse and obtain debts, receive the consideration of sale, mortgage and insurance, and dispose of and manage and invest those funds. He is also entitled to rent properties, evacuate tenants, remove the usurping hand. And then the final point on that, on the POA, is at page 181. Approximately halfway down the page, which provides Abdullah with the right to sign all documents on our behalf and without the need to obtain approval.
I don't have that one. Whereabouts is that?
So page 181, it's the beginning of the final sentence on the first paragraph of that page. Beginning, he shall also have.
I'm looking at a power of attorney which came from page 913 of the hearing bundle.
I think I'm looking at an alternative translation of the same document, which is at page 181.
Well, which translation am I acting on? I wasn't, I say, to make it plain, I was not aware that there were two. I got this reference from somebody's skeleton argument. I can't remember whose, and that's the one I looked at.
Yes, Your Honour, I think we might have been working off a different document because I had the document starting at page 179 when I had looked at it. It may be that I can go back and dig out the reference in your version.
That I know which one I'm meant to be looking at. This is the common problem when using translations.
Yes,
is there some agreement on that?
Perhaps, Your Honour, I can take some instructions on that. I can make my point about the document I'm looking at now, and I'll go take a look at the later version, see if there is any one legitimate difference, but also any dispute between the terms in which they've been translated.
Well, now you've referred to some points, and I've made a note of them, of the points the parts that you're referring to. Your point is what? That they give Abdullah power? It's as simple as that?
Yes, simple as that. So we would invite this court to reach the same conclusion as the Shareholder Court of Appeal, which is that the 2008 POA on its own terms is broad enough to permit Abdullah to act for and bind the BVI companies. And I'll come on to explain that in the context of Geomatic.
I wish you had taken the hint and not referred to the Shareholder Court of Appeal. Please don't do that again.
Certainly. So that's the POA. Your Honour, what I propose to do now is to take you to some of the authorities. Now, I think that for some reason the authorities for my skeleton were provided as a different bundle, which I think requires one to go out of the, or at least open a new tab to the case lines bundle containing the hearing bundle documents. And there should be another one, but I don't know if Your Honour has managed to find the Respondents Authorities bundle.
I have two Respondents Authorities bundles.
Okay, I think as long as you have those, it should be that when you open tabs, it has a numbered list of 23 authorities, starting with the Law Property Act. So as long as we're working off the same thing, I can take Your Honour to the relevant page references.
Okay, except that when I go do that, it has logged me out and I have to log back in again. Right, I have the Claimant Authorities bundle open. What am I looking for, please, Mr. Doherty?
Thank you. So it's, first of all, I want to take you to the way that the general statement of principle is put out in Bousted and Reynolds. That's at page 577, and I think it should be tab 15.
Yes.
the first page, or the beginning of the section I refer to, which is Chapter 1, Section 28, begins at 577, which relates to attributing acts, omissions, and states of mind to companies. And the first reference in that I draw your honour's attention to is over the page at 578.
Yes, I've got that.
Where we find a reference there to the case Meridian Global Funds and Securities Commission.
Yep.
And in particular, it's from the final sentence beginning with the primary. What it says is that the primary rules of attribution are best seen, it is suggested by the authors, as simple sources of actual authority vested usually in the board of directors, but sometimes in the shareholders. And it continues. At the bottom of the page, the final sentence, equally, and to the extent that some of the functions of shareholders in a general meeting or in giving informal unanimous assent involve participating in decision making on the company's behalf with a view to alteration of the company's legal position, they act as co-agents. And then at the next paragraph, the statement of principle continues. Normally, directors and shareholders will have actual authority as opposed to apparent authority, only when they make their decisions in accordance with the procedures established by the statute and constitution. However, both in relation to directors and shareholders, the courts recognised early on that these groups could also bind their company informally, so long as it could be established that all directors or all shareholders, as the case might be, assented unanimously to the decision being made on the company's behalf. And it's interesting that it says there on the company's behalf, not by the company. In respect of the shareholders, Lord Hoffman in the Meridian case approves the formulation of the concept as follows, and then it references Lord Hoffman's judgment, saying the unanimous decision of all the shareholders in a solvent company about anything which the company under its memorandum of association has the power to do shall be the decision of the company. So the important takeaway point as a statement of general principle is that the unanimous decision of shareholders binds the company. And in effect, the statement of Lord Hoffman that I've just referred to summarises the geomatic principle, which I'm going to come on to in more detail.
Yep.
Geomatic itself, Your Honour will find, again in the authorities bundle at tab 11, beginning at page 446. And while Your Honour's finding that, I should say that the facts of that case aren't overly important in the present context. Essentially, the action was brought by liquidators who were seeking repayment of sums that they'd paid out to two directors who, at the time the payments were deemed to have been approved, were also the only ordinary shareholders who held voting power within the company. And it had been common ground that the payments weren't authorised by a resolution of the company at a general meeting. So the argument before the court was ultimately whether that mattered, because all of the shareholders with voting rights had approved the payments. And the way it was approved in that case was, in effect, by those shareholders with voting rights drawing up and approving the company accounts, which made certain provisions for director remuneration. And the first extract from Geomatic that I refer Your Honour to is at page 454. That's of the bundle.
Yes, I have it.
Beginning at A. This is Mr. Justice Buckley, who says, "It seems to me that if it had occurred to Mr. Elvins and Mr. East at the time when they were considering the accounts to take the formal step of constituting themselves a general meeting of the company and passing a formal resolution approving the payment of directors' salaries, that it would have made the position of the directors who had received the remuneration, Mr. Elvins and Mr. Hanley, secure, and nobody could thereafter have disputed their right to retain the remuneration. The fact that they did not take that formal step, but nevertheless did apply their minds to the question of whether the drawings should be approved as being on account of remuneration payable to them as directors, seems to lead to the conclusion that I ought to regard their consent as being tantamount to a resolution of a general meeting of the company. In other words, I proceed upon the basis that where it can be shown that all shareholders who have a right to attend and vote at a general meeting of the company assent to some matter which a general meeting of the company could carry into effect, that assent is as binding as a resolution in the general meeting would be.
Mm-hmm.
So that's the classic statement of the geomatic principle. It's a principle which cures a lack of formality in order to give effect to unanimous consent on the part of the shareholders. It's not a particularly new point of law, and in fact it's one that goes back quite some time. And Your Honour will have noted that I've also quoted an extract from the well-known Salomon case in my skeleton argument at paragraph 49. Now that case is often referred to in the context of the distinct personality that a company exists by relation to its shareholders. But the important extract is the judgment of Lord Davey. And as I say, it's at my skeleton, but I'll read it out for ease of reference, which is, I think, an inevitable inference from the circumstances of the case that every member of the company assented to the purchase, and the company is bound by matter inter vires by the unanimous agreement of its members. And the purchase referred to in that context was the sale of Mr. Salomon's business to the company.
Mm-hmm.
So for present purposes, the claimant relies on that simple statement of principle. The company is bound by the unanimous agreement of its shareholders. That principle was further explored in a way which is relevant to this case in multinational gas, which Your Honour will note I've also referred to at paragraph 50 of my skeleton, and you'll find at tab 13, page 496. And there are a couple of threads that can be drawn from that. And just while Your Honour is getting up the reference, the facts there are that we have 3 oil companies who are in a commercial enterprise together, and they form, as shareholders, the claimant company, which is incorporated in Liberia. The 3 oil companies were the only shareholders. The company subsequently went into liquidation and brought actions and negligence against the shareholder oil companies, as well as company directors and advisors. And the context of this decision is an application to serve outside the jurisdiction, which required the court to consider whether the defendants had a good defence to the action. And the decision is that the application would fail because the shareholders and directors had a good defence based on the geomatic principle, which is that the company was bound by the unanimous assent of its shareholders. Now, the relevant extracts of the judgment that I want to take Your Honour to begin at page 506.
Yep.
First of all, in between E and F. The paragraph beginning, the submission in relation to the defendants was as follows. No allegation had been made that the plaintiff's directors had acted ultra vires or in bad faith. What was alleged was that when making the decisions which were alleged to have caused the plaintiff loss and giving instructions to services to put them into effect, they had acted in accordance with the directions and at the behest of the 3 oil companies. These oil companies were the only shareholders. All the acts complained of became the plaintiff's acts. the plaintiff, although it had a separate existence from its oil company shareholders, existed for the benefit of those shareholders who, provided they acted inter vires and in good faith, could manage the plaintiff's affairs as they wished. If they wanted to take business risks through the plaintiff, which had no prudent businessman would take, they could lawfully do so. Just as an individual can act like a fool provided he keeps within the law, so could the plaintiff. But in its case, it was for the shareholders to decide whether the plaintiff should act foolishly. As shareholders, they had no duty to those with whom the plaintiff did business. It was for such persons to assess the hazards of doing business with them. It follows, so it was submitted to the plaintiff. As a matter of law, cannot now complain about what it did at the shareholders' behest. So that's effectively a submission which is building a little bit on the geomatic principle. It makes the classic statements that the company exists for the benefit of its shareholders, and it's for the shareholders ultimately to decide that it should act in a particular way, and if they do, then it becomes an act of the company.
That's the submission. What was the court's decision?
Yes, I'll come on to that in due course. The other reason for highlighting it, of course, is that it feeds into the potential relevance of some of the allegations of sham, which I'm not going to trouble Your Honour with. But the point really is that the principle is not necessarily displaced by an argument that a transaction was at undervalue or that it wasn't prudent.
Yeah. Mr. Doherty, my question was, what did the court say, not the submission?
Yes. If we go over to the following page.
Yeah.
We have, first of all, this is Lord Justice Lawton's framing of the principle, beginning A to C. Which I won't read out, but you can have for your note. Skipping forward in the judgment to page 518.
Right, 518.
Yes.
So we're now in Lord Justice May.
Yes.
Yeah. Well, were you referring me to anything that Lord Justice Lawton was at, sir?
No. The purpose of taking you there, Your Honour, was to show you how it was that the case was being put, which obviously feeds into their lordship's decision.
So far, that submission has not been accepted.
Yes. Yes, right. I take that.
Can I say again, what did the court say?
Yes, Your Honour. The point I make is that the court rejected the claimant's position and said that the geomatic principle applied. So the point is that that submission is one which holds. It doesn't matter what the basis of the shareholder's decision is, or if it's imprudent or not. That's not fatal to the application of the principle.
Mr. Doherty, please, you've been around long enough to know that a submission means nothing. If you want to refer me to what the court says about it, then do so. Yes. Otherwise, let's move on.
Yes, Your Honour. Moving on, as I say, to Lord Justice May's speech.
Yes.
At 518. So this is beginning just below B, with it's well established. So it's well established by such authorities as Solomon and the many authorities to like effect, to which we refer, that a company is bound in a matter which is intra vires and is not fraudulent by the unanimous agreement of its members or by an ordinary resolution of a majority of its members. I do not think that this line of authority establishes anything more than that a company is bound by the legal results of a transaction so entered into. That is to say, for instance, by the terms of contract, which is so approved, or that neither it nor, for that matter, liquidator can challenge the legal consequences, such as transfer of title of a transaction to which its members have agreed to the extent I have mentioned. So the point here is that the scope of what a company is bound by in those circumstances is, provided it is inter vires and it's not fraudulent, the company is so bound.
Right.
And the next extract from that case, which I refer Your Honour to, is at 527. And this is Lord Justice Dillon.
Yep.
And this is at G, or just above G, a couple of lines above, beginning with the case set up, is that all the shareholders, the joint ventures, made the impugned decisions at the outset. Insofar as the decisions were made at the 3 meetings in New York and Paris referred to in the statement of claim, it matters not that these meetings were called board meetings rather than general meetings of the plaintiff. It would equally matter not if the decisions were made by all the shareholders informally and without any meeting at all. And he refers to the well-known passage in Lord Davies' speech in Salomon, the company is bound by a matter inter vires, and that was apt to cover the present case. So the point being emphasized there feeds into some of the submissions on formality, and the point really is that a decision can be made informally. It can bind the company regardless of whether it's by a resolution, whether it's made at a meeting of the shareholders or not. As long as we have unanimous consent, the company is bound by that agreement. And I'll come on to refer to that in the context of what my learned friend says about how companies' decisions and how the execution of decisions by companies needs to be carried out. But before I do that, the final authority that I want to refer Your Honour to is the Siban case, which you'll find at page 532, tab 14. Which is a Privy Council decision. I'll give Your Honour a brief summary of the facts of that case.
Hang on a second till I get there. I was,
of course,
slightly distracted. Yes, I have it. Mm-hmm.
So what we have in that case is there is a Brazilian businessman who's the ultimate beneficial owner. So he's Mr. B, who seeks to arrange his affairs in such a way as the court found to shield his assets from creditors. And to achieve that end, he acquires the BVI company, so that's Spectacular, or Siban as it became, which he then holds through bearer shares. Spectacular appoints the defendants to the action as corporate director and the registered agent. But in practice, what happens is that Mr. B's long-standing business acquaintance, Mr. C, gives instructions to the defendants on Mr. B's behalf, requiring actions to be taken in relation to the companies. And the specific acts in this instance include instructing the issuance of a number of POAs to a number of different entities and individuals. So initially, in 4 instances, those actions or those instructions were known to and directed by Mr. B as the ultimate beneficial owner. The reason that the claim arises is because at a point in time, Mr. B owes a sum of money to Mr. C, and unbeknownst to the beneficial owner, Mr. C instructs the company to issue him with the power of attorney, which he then uses to sell company assets and pay himself back, in short. So the claim was premised then on various alleged breaches of fiduciary and tortious duties against the corporate director and the registered agent. The question posed by the court, which is relevant for today's purposes, starts at paragraph 31 of the judgment, which Your Honour can find at page 546. Which is the beginning of the court's explanation of the background to the geomatic principle and its effect.
Yep.
And I won't take Your Honour through the whole of that rationale. In effect, it repeats some of what we've already looked at. So it goes to geomatic, it goes to Salomon, it goes to the multinational case. And then if we go forward to page 548, we get the application of the principles to this case, starting at paragraph 37.
Mm-hmm.
And what Lord Burroughs says there is that applying the geomatic principle to our case, Spectacular would have been bound had the sole shareholder, Mr. Byington, consented to Mr. Costa's having authority to give instructions. That informal giving of consent by Mr. Byington, who's the ultimate beneficial owner, explains how, and this was not in dispute, Mr. Costa had actual authority to give instructions to TCCL and Sitco, so that's the director and the registered agent, in relation to the first 4 POAs. But in respect of the 5th POA, which is the one which was used to fraudulently sell the properties, Mr. Byington clearly did not consent by giving Mr. Costa actual authority. And pausing there, first of all, we say that the important point that arises is that by informal action, in this instance, the ultimate beneficial owner and shareholder has provided his consent in that capacity as shareholder of the company to Mr. C, his agent, having the power to direct the way the company acts. So in this case, it's by giving instructions to the directors and to the registered agent, which they're bound to act on. So breaking that down, we have Mr. B, who as shareholder, it appears to be accepted, has the power to require the company to act in a particular way. And what he does informally is consent to Mr. C possessing that authority and giving those instructions. And the consent in that instance is one which is given by the unanimous consent or the unanimous act of the shareholder. And it's that which then binds the company to act in accordance with the instructions which are then given by Mr. C. Now, as alluded to in the final sentence of that paragraph, the court also considered it from a slightly different perspective as well, because when it came to the fraudulent instruction, if I can put it that way, which was the subject matter of the claim, that was on the basis that the ultimate beneficial owner had not given consent by providing his agent with actual authority in that instance. So the question that was being considered by the court as we go on to paragraph 38 is whether such unanimous consent could also arise and whether the agent could have ostensible authority in those circumstances, even though the ultimate beneficial owner didn't know about the actions that his agent was undertaking. So we have paragraph 38. The question therefore becomes whether one can apply the geomatic principle of informal unanimous shareholder consent to ostensible authority. As a matter of principle, there seems no reason why not. If actual authority can be conferred informally by unanimous shareholder consent, the same should apply to ostensible authority. So here, Mr. Byington's informal consent to the representation by conduct that Mr. Costa had authority to instruct the directors binds Spectacular, so binds the company. That point is an important one in the context of my learned friend's submission, because one of the things that he said in his oral submissions was that the geomatic principle can only apply where the shareholder has some direct knowledge of the act that's being undertaken or being purportedly undertaken on his authority. But clearly that's not quite the case here, because what the court's doing is extending the principle to say it can apply in a situation where ostensible authority arises. So that means that the ultimate beneficial owner doesn't have the direct knowledge of what Mr. C is doing. Because of course what Mr. C is doing in this context is defrauding the beneficial owner. But the point is that the company is still bound by that act. If we go on to paragraph 39, Lord Justice Burrows goes on to explain why the informality of the beneficial owner's decision making is also immaterial in this context. So he says it's important to add that the geomatic principle explains why there is also no problem about the informality of Mr. Byington's conduct. And I'll come on to this as well, even in relation to Section 80 of the IBC. This is because if it was reasonable for TCCL to rely on the instructions of Mr. Costa on the basis that he was conveying the instructions of Mr. Byington, the ultimate beneficial owner, there would be no need to go through the formality of company resolution ratifying the sale. As far as TCCL was concerned, Spectacular would have already given its authorization through Mr. Byington. So there are a couple of points there. One is the need in any event for director consent. So what we would say here is that director consent isn't needed because Spectacular has already given its authorization through the shareholder. And I suppose to put it in the context of that case, we have Mr. B, who has no corporate authority, as my learned friend put it in his skeleton, who gives his shareholder authority to Mr. C, who it's also accepted has no corporate authority. But what Siban tells us about that is that the board are nevertheless bound to act on Mr. C's instructions as though it's an instruction from the shareholder, and which is binding on the company without the need to have the director sitting in the middle. The extract of paragraph 39 is also relevant to the submission that we heard earlier this morning on the requirement for director consent, where we've got a disposition of more than 50% of the assets. Now, I suppose a couple of points. There really isn't much material before the court on that point or what BVI law says about that. It seems to have been taken somewhat opportunistically on the basis that it was set out in Siban. It's asserted that it bites, but in my submission, this isn't a case where we can come close to saying that, because first of all, we're not talking about the properties being sold. We're talking about there being a lease granted over the properties. So there's no evidence on that basis to suggest that there's been a disposition of 50% of the company's assets. It doesn't seem, as a matter of common sense, that a 15-year lease would have that effect. So we say that there's nothing to suggest that it would buy anyway, and the defence haven't put any evidence forward to suggest that it would. But more importantly, Spectacular lost on that point in Geomatic. So if we look at paragraph 39, from where I finished off, it says that the geomatic principle can be applied not merely where the requirement for formal approval derives from the company's articles, but also where it derives from statute, is demonstrated by, and it refers to in Ocean Care Investments. This will turn in the correct interpretation of the statutory provision in question, but in our view, which is consistent with the Court of Appeal's reasoning, that Mr. Byington, in his capacity, the sole member, must be taken to have approved the sale, Section 80 of the IBC should not be construed as removing the geomatic principle. In other words, the submission made this morning by the defendants can't be correct because the statutory provision, as expressly held in CBAN, does not displace the effect of the geomatic principle. So, Your Honour, drawing some of those threads together, Salomon and geomatic, as long accepted principles of law, tell us that a company is bound by the unanimous acts of its shareholders, and that's regardless of whether the decision is made by them formally or informally. What we say is that that means that the unanimous decisions made by the first to third defendant shareholders, so that's Majid and Mohammed Al-Sari, are binding on the company, whether or not there has been some exercise of corporate authority by its director, Air. Multinational Gas confirms to us that there's no special rule of formality that latches onto that principle, and that those decisions can be made without a meeting. What CBAN also tells us is that a shareholder can similarly act through an agent, as Mr. C did for the ultimate beneficial owner, Mr. B. So Mr. C is giving instructions to company directors that are binding on the company, and that is instructions that are made carrying the authority of the sole shareholder, who is thereby acting with unanimous consent of the shareholder. And we say that there's nothing in principle, or as a matter of law, which would stop Majid or Mohammed Al-Sari from appointing an agent in precisely the same manner as in CBAN. And that's exactly what we say has happened through the 2008 power of attorney. Abdullah Al-Sari signed the tenancy agreements, and in doing so, he had the requisite authority to bind the BVI companies. And that authority is derived from the unanimous consent which is provided by the shareholders of the company. So to put it the way Your Honour did this morning, if Abdullah can do what Majid and Mohammed can do, geomatic tells us that Mohammed and Majid were able to enter into the tenancy agreement, and by extension, we say that it's clear as a matter of law, Abdullah was able to enter into that agreement as well.
Or more accurately stated, able to cause the company to enter into the tenancy agreement.
Yes, yes, quite right, Your Honour.
I'm sure that's what you meant, but
it is. The defendant's case in my submission doesn't really address that core point. What it effectively boils down to, as Your Honour observed, a submission that all the shareholders could do was to pass a resolution requiring the execution of a particular act, but that act needed to be taken by the directors. Our position is that that's not correct, because a company can, on the application of the principle which I've gone through, be directly bound by those sorts of unanimous agreements. And CBAN confirms that ultimate beneficial owners can appoint an agent with the power to bind the company. That's clear. And in fact, that's what Lord Justice Burrows said at paragraph 37, which is worth repeating. It's spectacular would have been bound had the shareholder, Mr. B, consented to Mr. C having authority to give instructions. That wasn't in dispute in that case. That happened on a number of occasions. The principle also extended to acts that were undertaken without the shareholder's knowledge. We don't quite get to that territory because, of course, in this case, we know that Abdullah's authority was expressed because we have the POA. But I suppose for what it's worth, on a similar point, there are a myriad of different scenarios in which a company can act without the execution being carried out by its directors. An example of that, which Your Honour has already been referred to, is in the Healy-Hutchinson case, where of course we have the chairman of the company who doesn't exercise corporate authority in the way that a director does, is still in a position to bind the company in that case. And then bringing that back to the statement of principle in the Meridian case, which I referred to at the outset, the unanimous decision of the shareholders in a solvent company about anything which the company, under its memorandum of association, has the power to do, shall be the decision of the company. There's no middle step in there requiring that the only thing a shareholder can do can require a director to execute. The point is that the company members can make the decision whereupon it becomes directly binding on the company. And so my learned friend's main point seems to be that you can't cut out the directors, but we say that's precisely the effect of the geometric principle. He says that the articles require the business of the company should be managed by the directors. Well, that's no different to almost any set of company articles. The point is that the geometric principle applies to turn informal unanimous agreement into formal acts of the company. In effect, in my submission, what my learned friend tries to do is to impose a formality requirement on a rule which deliberately exists to try and get rid of those formality requirements in situations where there's unanimous consent. So I have to disagree with my learned friend on what he says about that. Back to the simple question, we say Abdullah has authority to do what Mohammed and Majid do, and Mohammed and Majid had authority to bind the company. That, in a very simple statement, is what our position is on authority, at least insofar as it relates to our primary argument.
Yes, I follow that. Thank you.
Thank you, Your Honour. For what it's worth, and I'll try to go through this as succinctly as I can, but I think I need to say something about the alternative basis on which the case is put anyway. Because we say that it's not only the primary analysis where the defendant's application comes unstuck, but it's also misguided when one views this case in the context of implied actual authority. And I don't think that we disagree on the law on this point. We've both referred to Healy-Hutchinson. Your Honour will find that case at tab 16 of the bundles. That's page 598. And I've already alluded to that. The facts of that case concern actions taken by a chairman who was held to have had implied actual authority because he was acting as the company's de facto chief executive, and that he did that with the acquiescence of the board of directors. The extract of that judgment, which I'd refer Your Honour to, is at page 663.
Well, that's a fairly well-known case, I think.
It is a fairly well-known case. In which case, I don't think I need to take you to it. I think it may well be set out in my skeleton anyway. And as I say, it should be uncontroversial. We agree on the relevance of that authority. The point that arises from that statement of principle is that implied actual authority is something which arises from the circumstances of the case. And in that context, authority to act for the company is something which would arise from the acquiescence of the board. And the first point I make about that, I in fact make by reference to some of the things my learned friend has said in his skeleton argument. So first of all, at paragraph 34, my learned friend relies on the marine blast case, which says that the court approaches that question by looking at external objective circumstances, and that included in that case communications between the parties, and their conduct. The second authority that my learned friend relies on is MVV. That's a paragraph 38 of his skeleton. But it's at page 117, just for your honour's note, of my learned friend's authorities bundle, which is an extract from the judgment of His Honour Judge Pelling QC, who says that, and I'll quote it for ease, all other issues are questions of fact that arise from the particular circumstances of a given case. He goes on in his judgment to refer to another case, Sino Channel Asia and Dana Shipping, and says that the focus in the case of implied actual authority is on the actual circumstances of the relationship between the principal and agent, hence on what may be inferred from the conduct of the parties. And His Honour Judge Pelling concludes that inevitably the outcome of particular cases are fact sensitive and will at best only be of very limited assistance in arriving at a conclusion in any other case. So effectively what he's saying is, we know what the principle in Healy is. Comparative exercises of looking at different cases aren't really of assistance because each case turns on its own facts. And the point we make, first of all, is an obvious one, but it's an important one, which is that when the court considers whether or not there's implied actual authority, it conducts a factual investigation. And we say that's not a narrow factual investigation because the existence of authority in those circumstances is something that has to be determined by reference to all the circumstances of the case. And it was on that basis that in the MVV case, His Honour Judge Pelling pointed out that the cases don't turn on questions of legal principle, they turn on facts. And because of that, we say that this is a case which needs to go to trial. And Your Honour's already, of course, been referred to it. You don't need to be referred again to GFH. You know what it says. But a couple of points do bear stressing. The purpose of this exercise is not a mini trial. The court isn't tasked with resolving conflicts of fact on this application. We have to consider what evidence will be available for trial, where there are allegations of fraud, or in this case, a sham, which one might view as approaching that sort of allegation. Those are particularly problematic in summary disposal because, for starters, it requires the court often to draw inferences from facts, as well as conducting investigations as to states of mind of participants.
At the moment, however, we're not interested in sham or states of mind. We're just interested in whether there is a case demonstrated for saying that on the facts there was implied actual authority.
Yes.
So now just tell me, from the evidence, your best three indications of implied actual authority.
Yes, Your Honour. I suppose the first thing to do would be to summarise, and I won't take you to it, but it's the evidence of Mr. Colin Denvers, who explains the setup and operation of these various companies and how the properties were managed. And I'll be brief on that. What he says is that he's the director of a company, Hurling Management, and that he's always acted as the managing agent for the bridge ever since it was purchased. He was also involved in the incorporation of the BVI companies, and says that he was really involved in the day-to-day management of the accounts, payment of their invoices, and so on. And he refers to a number of contemporaneous documents in support of that. And again, I'll not take Your Honour to them, but they're things like council tax bills, electricity, water bills, which we can see contemporaneous notes which say paid for by Hurlingham. He also tells us that he's the liaison between Coutts & Co., Mr. Mohammed Al-Sari, and the BVI companies, and that in carrying out his function, he takes instructions from Mohammed Al-Sari and that he's authorized to act on behalf of the Al-Sari family. And what he says is that although the BVI companies have corporate directors, so that's heir, and we've got the individuals who effectively act as company directors beyond that. He says that they didn't play any significant role in management. Their role was limited to maintaining company documentation, and that the day-to-day management was carried out by him on the instruction of the beneficial owners. So that's the first feature we'd point to. The second is a number of agreements, which he refers to in his witness statement as well, from paragraph 49 onwards. In particular, Your Honour will have seen reference in my skeleton argument to 2011 loan documentation. Your Honour, I can take you to that or not for your notes at the very least. It's in the hearing bundle at page 1003. And in fact, I think it may well be worth going to that. It'll involve coming out of the bundle you're currently in and going back to the main bundle.
Well, tell me again, what is it? Give me a summary of what you're taking me to.
Yes, so this is it's loan documentation between Westdean, one of the defendants, and Coutts & Co Bank.
Yes, just tell me how do you use that as an illustration of facts from which implied authority is found?
Yes, so and I'll give these to you for your notes. So 1003, we can see that it's a letter from Coutts Bank addressed to the directors of Westdean. At page 1005, we see that it's got two signatures, which Mr. Cohen-Denvers explains. One is Mr. Hurd, so he's one of the directors of AIR, who's a director for the company, and the other is Mr. Mohammed Al-Sari. So, as at 2011, the directors, or the corporate directors of the company, can be taken to have had the knowledge that the beneficial owners are signing documentation which it says on the signature block is for and on behalf of Westdean Investment Limited. At the page after that, at page 1006, what the loan documentation also says is that it includes a comment that the property will be occupied by Majid Al-Sari, brackets, brother. So I suppose there are 2 points there. The reference to brother, again, is obviously an acknowledgement that the person who was to sign this loan document was Mohammed, but also that Mr. Hurd, who signed the documentation, will have known about the fact that the properties are being occupied by the Al-Saris.
Well, that's two. What's the third one?
Yes. Third, we have page 1024. Which is a letter from Mr. Cohen-Denvers to Mr. Mohammed Al-Sari, who is referred to in the address section as being director of Westdean. And what that letter is asking for is for particular loan documentation to be signed by what Mr. Denvers describes as the A list of directors, and he lists in 3 bullet points Abdullah, Majid, and Mohammed Al-Sari, and one of the B list. And that, he says in his witness evidence, refers to the nominee director heir and those who signed there. So the point arising from that is that we have contemporaneous evidence of the Al-Saris being treated as the de facto directors of the BVI companies in an analogous way, say to Healy Hutchinson.
Treated by who?
Treated by the officers who possessed the corporate authority of the company. So that's Mr. Hurd.
That from? Why do we get that from that document?
Because that's the way in which company documentation was being executed. So we had the 2011 loan agreement, which is signed for and on behalf of Westdean by Mohammed Al-Sari and by Mr. Hurd. So Mr. Hurd can plainly see.
That's your second one. What about this third one, though?
Yes, the point of the third one is to say that this was the process that was followed and understood to have been followed, which is A list and B list. But the point is that the A list, we say it's implied in this case, had the authority to act for the companies because that's what they had been doing.
Right. So it's not so much an illustration of an act, but rather a proposition from Mr. Denvers that that is how things were done.
Yes.
Right.
Yes, correct. And I think it's to make the point as well as that it's not just understood that it's, say, Mohammed Al-Sari alone who holds that special status as an A-list director. It's Majid and it's also Abdullah. So that's what we say can be derived from that letter.
Okay, thank you.
And I won't go to it as well, but it's in my skeleton. We do also have further documentation which relates to the transfer back of sums paid by Igpl by the companies of £400,000. But Your Honour will note that the documentation sent to Coutts Bank to authorise the transfer back was in the same format. So we've got Mr. Mohammed Al-Sari and Mr. Hurd signing that document. And again, that seems to have been something which was acceptable to the bank.
Okay.
Your Honour, we also make some points about effectively there's a submission surrounding the secrecy of this agreement and the fact that it was unknown to the corporate directors of the company. But even putting aside the way documents were signed, we say that that's not a submission that actually works. First of all, as I've already taken you to, the company documentation makes reference to the fact that the premises are occupied by the Al-Saris. We also, beyond that, have a situation in which the directors have not sought to take any positive steps to deal with the properties in some way. So feeding into the point about whether or not this is a commercial transaction, the directors will have known that the properties were vacant. They didn't try to lease it out to anybody else.
Let's not trespass into sham.
Yes, I think the point there is that it builds into what the company, by its corporate directors, understood the situation to have been at the time, and whether in turn they can be said to have acquiesced to a state of affairs whereby the properties were managed directly by the shareholders and also occupied directly by the shareholders. So the point there is to say that, well, if the company didn't know anything about this arrangement, and if it didn't know anything about the tenancy agreement, then one can quite properly ask at what point the directors stood up and said, well, hang on a minute, we're directors of this company, and we've got 3 vacant residential premises that we haven't done anything with for the better part of 15 years. So what we say is that that feeds in to the court's consideration of the question of whether there is implied actual authority, because if the company didn't acquiesce to the way that the property was being dealt with by the beneficial owners, and that it didn't thereby give them implied actual authority to deal with the properties in that way, then where is the evidence that shows that they were trying to deal with the properties in some other way? So I suppose drawing those threads together, where we say that gets us on implied actual authority is that Abdullah Al-Sari is one of the A-list of directors authorized to sign on behalf of the BVI companies, or at least is understood to have held that position. Even if that's wrong, Majid and Mohammed would have held that status, and they authorized Abdullah by power of attorney to act on their behalf, so he could do what they could do. We say that the tenancy agreement ultimately reflects what the company's directors will have already known was happening with respect to the properties. That is, that they were occupied by the Al-Saris and that the ongoing operating expenses were not being picked up by the company themselves. They weren't incurring those liabilities directly, which again, the company would have known, and that it hasn't sought to otherwise deal with the properties in some way. Likewise, the company has never sought to raise any queries as to why it, out of its own accounts, hadn't been paying various liabilities that were obviously being incurred, such as service charges and other costs. So in all of the circumstances of the case, we say that the court can find that the company directors acquiesced to Abdullah having actual authority to enter into the tenancy agreement, and that the company's directors therefore did have the requisite state of knowledge, as my learned friend puts it, as to what was going on. We say that it's certainly at least arguable, for the purposes of the present application, that there was implied actual authority. But at the very least, because the court is being invited to look at all of the circumstances of the case, including some of the factors I've drawn your Honour's attention to, that is something which is a matter for trial and for evidence, not for summary disposal.
Yes, thank you. I follow. But anything else?
Your Honour, those are my submissions on agency. I take it you don't want me to do anything on sham. You've already decided. So unless you have any questions, those are my submissions.
Thank you. All right. Now, Mr. Osman, just take stock of timing. How long do you think you might be in reply?
I'm not going to be long, and that's a council. That's not without council tax on it. I'm not going to be long.
All right, let's do that and conclude.
I can almost do it by a sequential list of points. Can I just deal with the POA and the translation first of all? The one I took you to is at page 913 of the hearing bundle. That comes from Ms. Sheffield's exhibits. So I actually refer to the one that's been exhibited by the by Igpl. The one that Mr. Doherty referred you to was a translation which was actually attached to an earlier witness statement by Mr. Vedrigoli. I intentionally didn't refer to that. I referred to the one that Ms. Sheffield puts in evidence. So that's the reason why both of them come to their existence.
Well, unless someone says otherwise, I will act on the page 9131 on the basis that it comes from the from Igpl.
Yeah, that's the position that I've taken on. So that's in relation to that point. Really, as ever with these matters, things start to really boil down and distill, and they have here, particularly in relation to, frankly, the outstanding issue of thesis 1 of authority, and it's really that. I am only going to refer to that. Can shareholders bind a company? Yeah, of course they can. They do by resolution. Are in these circumstances, for the purposes of argument, the POA sufficient for Abdullah to take Mohammed and Majid's place for the purposes of this immediate judgment application? Yes. albeit I make previous points which I've got already, but for the purposes of the discussion. So we're there in relation to Abdullah effectively standing in the shoes of Mohammed and Majid. Where we differ between myself and my learned friend is that what is it that Abdullah can do? Abdullah can make resolutions, and then if you go to what that means, the resolution means that the company is therefore bound by the decision, but executed by the directors. And the reason I say that is because of Article 62. The business of the company shall be managed by the directors, etc., 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 to such requirement as may be prescribed by the resolution of the members. Again, agreed. The question is it possible for Abdullah to sign on behalf of the companies to do the business? And what my learned friend says about that is that Geomatic gives a positive answer to that question. And so can I briefly take you to what Geomatic says? And forgive me, I'm working on the actual authority itself, so I can't give the authority page number. I'll read it. It's the head note, which is the best encapsulation of the position. And I'll read it. Held that where it could be shown that all shareholders with the right to attend and vote at a general meeting had assented to some matter which a general meeting of the company could carry into effect, the assent was as binding as a resolution in general meeting. And then it talks about the preference shares, etc. In that case, incidentally, in Geomatic, the shareholders and the directors were the same individuals. There's a swapping out at one stage, but that's essentially the position. But again, to reiterate, what Geomatic says and has always said, and it's a proposition law that is well known, is that if it can be shown that all shareholders have the right to attend and vote at meetings, had assented to some matter which a general meeting could carry into effect, that assent was binding as a resolution of the company. That's as far as Geomatic takes. It perfects the imperfection of an informal meeting, and a resolution is created. And again, if then one takes the import of that resolution into what the company can do, the company is managed by its directors as per and prescribed in the Articles of Association, prescribed by the resolution of its members. But the business is done by the company. So without risk of repeating myself, who can sign? The directors sign. And Geomatic does not effectively delete the board in that instance.
Well, just hang on a minute. Let me just think that through with you.
Yeah.
Let us postulate two different resolutions of the company in general meeting.
Yeah.
One resolution is resolved that the company lease the premises to the Al-Sari family.
Yes.
That is passed.
Yes.
The directors then take the administrative steps to cause that to be done. The other resolution is resolved that the directors be instructed to lease the premises to the Al-Sari family.
Yes.
Your proposition seems to be that only the second way can be done, and that because it is then necessary for the directors to, as you put it, execute, in the absence of that execution, nothing flows from the resolution. Do I have it up properly or not?
Not quite. May I respond?
Okay.
Resolution 2, correct. If the resolution says instruct the directors to do X, then of course the directors have got to do X, because that's the resolution. If the resolution says create tenancies on behalf of the Al-Saris, the creation of the tenancies is a matter for the directors, because the directors have the power to do the business of the company. So on both.
Okay, well, why isn't the position that is effectively the first resolution that I put to you, namely a resolution by the shareholders that the company lease the premises to the Al-Saris?
Yes.
Why is that not a binding resolution which purely as an administrative act the directors are then obliged to do, but it is nonetheless an effective act?
In
a corporate decision.
It is a corporate decision. The shareholders have made a corporate decision. What the shareholders cannot do after making that corporate decision is create and enter into terms on the tenancy agreement. Do it themselves.
But once that corporate decision is made, the company is obliged to do that. And if the company doesn't, the Al-Saris go to court and get an order for specific performance, which means that the directors have to take the administrative steps. Isn't that the result of your position?
No, my lord, because it's the position is this. That is a decision of the company. The directors effectively, on your proposition, have no discretion as to do what needs to be done. But it needs to be done. And the question in this case is who did it? Where you say it needs to be done and the directors are obliged to do it, if they don't do it, then that is action which the shareholders can take. It's effectively a derivative action in the BVI, which is what I was trying to attempt to deal with earlier, but put to one side. It's the wrong claim. If the complaint is, we told the directors to do this, it's a company decision, but the directors haven't done it, the relief is to go to the BVI and seek an order which compels the directors to do it. It is not, as in this case, a claim for specific performance of a contract which is said to have been done by the company by Igpl, because the contract was not properly done by the company, because the business of the company needs to be done by the directors. So I agree with your with the way in which the analysis flows. Forget number two, because I think we don't need to go into that. But number one, let's the absolute bare bones of it, distilled down to its purest question. Decision by company, binding on company. Decision binding on company, what happens? It is not the case that the shareholders, upon making that decision, can then create a contract. What happens is the directors are obliged to create that contract. The claim for specific performance in this case is not specific performance of the director's obligation to make that contract. The claim for specific performance of Igpl is that that tenancy agreement, which is said to be, because a requirement of specific performance, is said to have been properly done with authority, etc., is specifically performed.
Yeah,
and so
I see the distinction you are drawing, yes.
Yeah. And so, and to complete the point, it's why I spent, and again, forgive me, a rather tortuous effort previously of saying what Abdullah is actually saying is, I made this decision, the company's bound by the decision, the directors have to do it. But if that is the relief that he's seeking, he needs to go to the BVI to seek it, to compel the directors to do so, and that will probably be a derivative action. And it's not, but it's not this claim for specific performance upon a contract which is said to have been created by the company, and that's really what it comes down to.
Okay, I understand. Thank you. Yeah, you are right that the discussion has distilled matters.
Yeah, thank you. And then to further distill, I hope. I mentioned this about Siban. Let's not forget Siban was an action for injury against the directors. I mean, that was the cause of action. And so what was being said there was, look, the directors carried out this particular act because it shouldn't have, but it did act upon a POA. Sorry, it granted a POA and shouldn't, but it did. But the point that is important is, and this is where, with all due respect to my learned friend, he slightly stumbled when it comes to paragraph 37 of Siban, which is the key paragraph. It says, Mr. Acosta, the donee, had actual authority to give, sorry, no, it's not the donor, had actual authority to give instructions to TCCL, the director, in relation to the forced POAs. So the point is here, and was in Saban, is what the directors should or should not have done. But it was recognised in Saban that the decision needed to be carried by an act done by the directors. And so it's not a proposition, as my learned friend attempts to say, that effectively a unanimous decision carried by a nominee is the decision of a company, and then the shareholders can then go off and create contractual relations. Even in Saban, what happened then in those circumstances is it went up to the directors, for the directors to do what needed to be done for execution. So that was a point of distinction I seek to make with Saban. Section 80, my friend takes the point that it's a late comer to the party. Slightly bristle against that, because the whole proposition of position number one, which he now takes, is a new position. So that's why it's coming now. It's not in the skeleton argument. But be that as it may, the point is this: it didn't work in Saban, not because the argument was that the second stage of Section 80, the shareholders having to give assent to what the directors did, was not required because ostensible authority applied. But the point, my point in relation to Section 80, is that the first requirement of Section 80 is an act which the directors should do. And in Saban, they did it. But that wasn't the point in issue. The point issue was stage 2. After the directors had done it, did the shareholders ratify? And in Saban, they did via ostensible authority, and the directors accepted that. And the complaint was that they shouldn't have accepted it. So it's different. That's in relation to that. I just wanted to take you again to, I wanted to take you to Bouston and Reynolds, which is quoted in my learned friend's skeleton argument at paragraph 52, and he relies on it. I just wanted to properly look at this. And again, without having to need you to turn up, I can read it. And it says, normally, directors and shareholders will have actual authority. I agree. As opposed to apparent authority only when they make their decisions in accordance with procedures by the statute and constitution. Again, agreed. However, both in relation to directors and shareholders, the courts recognised early on these groups can also bind the company informally. Also correct, as long as it could be established that all directors or shareholders, as the case may be, assented unanimously to the decision being made on the company's behalf. So what this extract from Bouston and Reynolds on agency is effectively saying is that when you look through agency from the perspective of agency given by the directors, or indeed the shareholders, the principle espoused here applies. But this does not say, as my learned friend suggests it might, that what this essentially is authority for is that the shareholders can do everything, including the function of the directors, if they are just shareholders and not shareholders and directors as well. It's just a position statement in relation to how agency operates in either class of shareholder or director. So it doesn't help my learned friend in that sense. And then probably finally this, there has been, my learned friend was invited by you to give you his 3 best, his greatest hits, as it were, in relation to alternative scenario 2. I've dealt with this extensively in my skeleton argument, and nothing, with all due respect to my learned friend, that he has said upon your invitation, it deals with the aspects as set out in my skeleton argument in relation to consent and appurtenant requirements for implied authority, and also the inability to look sideways to gain a source of implied authority. So I just remind you, Honour, that I have dealt with it in that extent. I don't intend to engage with it again, because I will just be repeating myself. But those are my answers to that point. But the conclusion of the matter is this: as I said, as happens often in these processes of debate, it's really narrowed down. It's really narrowed down. And so there is a fundamental question, and the fundamental question is this: as per Article 62 of the Constitution, where it says the business of the company should be managed, as prescribed by the resolution of the managers, that is the position. And therefore the business, the creation of contractual relationships, even on the instructions of the members, must be done by the directors, and no authority gives license to the shareholders making that decision, albeit unanimously, and then by themselves executing that decision by contractual relations by bypassing the directors. And those are my submissions.
Yes. Well, I will reserve my decision. Now, there is floating around somewhere the discharge of the injunction application.
Yep.
I'm not sure what the current position of that is. The last I heard, that was meant to be listed at the same time as this application, which is the stupidest idea that there could have been. That does not seem to have happened, perhaps for that reason.
Can I inform Your Honour as to what has happened then? Yep. So direction has been made that the discharge application not be done, argued orally, but it can be done with skeleton arguments between the parties in that way. There is a huge amount of evidence that's been put before you in relation to this. There is another witness statement from each party in support of that application, but no real new evidence at all. And so the registry understandably took the view that the best way to deal with it is just to invite written submissions by the parties upon directions which are set by you now. So that's the current position. What that would require is for you to give directions on when those written submissions ought to be done, and then consequential directions. My invitation to you, Your Honour, is that when you give your ruling, because of course your ruling would determine if we ever need to have a separate application to discharge injunction, when you give your ruling, may we respectfully ask you, if necessary, to include directions upon the exchange of written arguments, and that's perhaps the most efficient way of dealing with the matter.
All right. Now, what about this question? It's now 7 months since the case started. If the parties had really applied their minds, they could have got the actual hearing up and running by now, or close to it, instead of messing around with immediate judgment applications and discharge applications. The question is this: do the defendants want to do anything in particular between now and when there can be a final hearing? Or is there any reason why the injunction can't be left and energies be devoted to getting the final hearing done rather than more time, money and effort being spent on the discharge application?
Two points play for that. Yes, there's been some time before since the application has been lodged. We don't need to engage you on this, but there's been, how should I say, some back and forth between the parties about listing, which has resulted in where we are now. The position with what's happening in the United Kingdom is important because, as Your Honour may recall, there were UN 4s and UN 1s which were lodged with the Lands Registry here, and there is currently a process ongoing where the argument as to whether those restrictions ought to remain or not they should remain. Those proceedings have been adjourned pending the outcome of these proceedings for obvious reasons. The injunction should not prevent that litigation from taking place, and if it doesn't prevent it from taking place, then it should continue. At the moment, there is a desire by the bank to try and market and sell the properties, but they haven't been put on sale or marketed yet because there's an injunction. And so one of the requirements to carry on with the process as soon as possible is to deal with the injunction. So I hear what Your Honour says, but my instructions are that the bank wants to carry on and get on with the job of realising these properties, which requires injunction to be lifted. Does that help, or do you need me to elaborate?
Well, it answers a question. There was a footnote in Mr. Pretlove's witness statement to the effect that he had sold, that something had been sold.
Yeah.
Let me just try and find what that was. It piqued my curiosity. The court has made an order sanctioning my sale of the shares following an application in November 2020.
Yeah.
That's the shares in the 3 BVI companies.
Yes. So
has Mr. Pretlove himself passed out of the picture?
Answer: yes. I'll tell you what's happened.
Right.
As you know, Mr. Pretlove was a receiver. He obtained the order for sale. The sale was done on what I understand to be a deferred consideration basis to a SPV, which is 100% owned by the bank, CBD.
So the bank is in fact giving instructions now.
Correct.
And the bank wants to realise further the assets which that SPV now has.
Correct.
Is that the story? Okay. All right. Okay. Well, look, all I would do is ask the parties, and perhaps it's more the bank than anyone else, to give consideration to whether the best course is just to get on and get a final hearing if the injunction can be left. I cannot see that the bank, I can see that the bank may not be very keen to start marketing anything if the ultimate decision goes against it. It doesn't seem a terribly sensible course. So why I ask myself, should it not say the best thing is to get on and get a decision, and then we will know one way or the other whether we are able to market it. So please consider that for whatever happens when I give my decision on this application.
I can't possibly answer that. I'll have to take instructions, obviously. So I will do this.
Yeah. All right. Nothing more, gentlemen? Anything from you, Mr. Osman?
No, just in relation to, well, I mean, costs will I'm sure that both parties want to make submissions on costs in due course, and that will be dealt with, no doubt, as part of the decision.
Well, costs are likely to follow the event, aren't they?
Yes, I just wonder, there may be some submissions on costs, and that would be more to...
Well, if you want me to not make any order about costs, but to give the parties the opportunity to make submissions, I will do so.
Please.
All right. Nothing else from you then?
No, thank you.
Mr. Doherty, nothing else?
You're on just a very brief point, which is the claimant's position on what next. I've summarised it, paragraphs 89 and 90 of my skeleton. I think probably what my learned friend says is right, which is that if there is to be some decision on directions after you hand down judgment, perhaps the parties can provide submissions in writing on that point as to the appropriate course if it's not agreed. That seems pragmatic.
All right. Well, the question, if I remember rightly, your submissions raised the question whether the discharge application should be on the papers or with oral submissions.
That's right.
We'll leave that then for a matter to be debated later on as necessary.
Yes.
Okay.
Okay. Thank you very much, gentlemen.
Thank you very much, Your Honour.